In this,
let him finish. Yes.
my lord, in this case, all the accused persons has been discharged, and the accepting this one, and the case is pending, and the
Give the memo. Discharge. Yes, sir. After
30, item number 30, madam.
you want an adjournment,
After launch, after launch.
I'll just yes,
302 case lordship. Item 30, my lord, is mentioned on 2 PM. 302. CD is not available, lordship.
then
My lord, earlier occasion I mentioned that
CD is available.
CD is not
I
One
verified,
case
lordship.
let it come. I'll see. I'll let it come. Yes.
restoration case matter specifically adding to 22 কিন্তু আজ পর্যন্ত 18
Give the memo.
Pardon to mention, my lord, item 25
I'll
of
call page
weekly-
wise.
let's say item 25 of weekly list was order was passed yesterday. Let's say, but the local police has detained the present petitioner late night.
Local police.
Detained to the present petitioner last night. Order was not uploaded in the website, lords.
Huh? What was that? Lord?
Let's say challenge the cognizance.
The local police has taken him to custody. What can I do? You have challenged the cognizance order.
Let's say order was also ever in the present petitioner. Let's see.
Have I quashed the cognizance order?
Let's see.
Which order? I don't think I.
Item 25 of weekly list.
25. We'll just check it up. Yes.
May I, with my lord's permission, mention a
25
matter?
item matter.
My lords, there's a batch matter of CRLMCs which my lords had posted for 9th of this month. My lords, arising out of an FIR filed in the economic offences wing. My lords, that arises out of a share purchase agreement, a whole batch, my lords. I'm appearing for one of the parties, my lords. We have filed the matter yesterday. And my lords,
You are one of the co-accused.
my lords,
You are one of the co-accused.
yes, my lords, we have filed the matter yesterday. We're trying to get the defects removed because counsel are traveling from outside. If it may come up on
removed,
night.
list it. If
Obliged.
defect is removed, it will be listed.
My lords.
Okay, lordship permission. May please. Vigilance case
Yes, yes.
hearing. It was before the vacation, it was before the list from October, would not reach. So I pray I will take only 5 minutes.
You take 5 minutes, but he'll take, I don't know how much time. And then thereafter, how much time I will take to dictate, I don't know.
2011. আর যদি এটা
Give, we'll see how to accommodate. Just check it up. Huh? How can you accommodate? But get ready with Mr. Tripathi.
My lord,
Get ready with the written note.
my lord.
That will be.
24 ପାରାରେ 24 ପାରାରେ ମୋ ନାଁ 25 ପାରାରେ କମିଟ୍
That one paragraph is so important. Yes.
205 rejected against that.
205.
The date has been wrong date.
Tomorrow, modification. Tomorrow. Only that modification or?
Cognizance order I think first title ठीक हो जाए और वो order टा भूले जो से
Tomorrow.
13 जगह 23 ही है
अच्छा, tomorrow. No problem. Yes.
mention item number 1 to 5
Item number 2.
2.
item number 9 9 item
1 minute. 2. Let it 2. Yes. He is there to oppose you.
Classes, I cannot out.
Now, whenever he wants an adjournment, he use these glasses. That's the problem. Okay. Entry order to continue. And you, Mr. Panda will start asking these glasses to you to be used in some other cases. Okay. Yes.
item 6 to 16
Item 9, my lordship. My lord, the compromise has been taken place between both the parties. Matter may be taken up at 2, my lord. Both the parties will.
2 o'clock?
Yes, my lord.
Okay.
Obviously.
Pass over. Yes.
item 17 to 24
Item 11, let's
11.
item 11 to pass over the after lunch.
It will be pass over, don't worry. Yes.
17 to 24
Item number 19. I'm from Angul. This
Yes, sir.
accused was Angul.
Yes, yes.
The accused was just absent in 1 day, and accordingly the warrant was issued, and therefore let him be. The court has sent the NBW in only 1 day.
What do you want, sir?
This I have filed the petition on section 482 CRPC. My
Okay, I'll allow it. I allowed. No. Allowed 19. Huh? Page number. Allowed, sir. Yes.
And your lordship, item number 24. I want to withdraw this case, your lordship.
Yes. Then counsel for the petitioner seeks to withdraw the bail application. 22, na? 22? 24. Okay. Granted. Yes.
25 to 28. 29 to 35. 36 and 37.
37 is implies to be filed.
You are supposed to file the reply. Some other day, you are not well today also?
I'm not ready.
Then note it down. You may go, but I'll give the date.
Another matter is after that at 5 o'clock.
This matter I'll give the date after the other side comes. Okay. Note kar rakh diyo. Yes.
38 to 42. 33 to 47.
Item 46 may be taken up, my lord, some other day, my lord.
Okay. 100. 41.
Interim order to continue.
One minute.
Interim order to continue.
Interim order to continue. Yes.
41 extension date of surrendering the extension. Because the 22 is the marriage, that is why the
41.
41.
And what which
Extend to 30.
no I had given the time.
Yes, 30th December. 31st December. Once it is
Time is extended up to so and so.
31st.
31st.
In marriage by 22nd to marriage date of the law code.
This is the second application on behalf of the petitioner for extension of time to surrender before the court below. As directed by this court, by order dated 6/11/2024. For the reasons stated in the application, by way of last and final opportunity, the time is time for surrendering or appearing before the court by the petitioner is extended up till 31st of January. It is made clear that no further extensions can be granted. Yes, allowed. The execution of NBW issued by the court, issued by the additional session judge special judge Korapur, its order dated 2/1/2024 shall be kept in abeyance till 31st of January 2025. Yes.
43 to 47. 48 to 56. 57 to 64.
58, my lord, I am appearing for the OP, but OP is not able to appear physically today. This is a compromise matter. Any other date?
What are the offenses?
492.
498. Other good week per day. 1 week per?
Yes.
For this one. Yes.
65. Item 1.
Yes. Please, your lordship.
Yes, sir.
But here the petitioner assails an order of cognizance, which I have annexed as annexure 1 to the petition.
Yes.
That's at page 13 of the brief.
Yes.
The court has taken cognizance under 294A, 420, 120, 120 IPC and 7(3) of the Lottery Regulation Act.
Yes.
1989 and issued summons, my lords.
Yes.
My respectful submission before your lordship is that the FIR and materials adduced during investigation, they don't make out a case against me. And the FIR appears to have been manipulated in view of the fact, my lords, that seizure lists which I have annexed to this writ petition, my lords, they indicate the PS case number when the seizures were allegedly effected before the FIR was registered.
Like, let us.
Your lordship may look
FIR
at
was
annexed-
registered on
Yes, my lords may kindly look at page 14 of the brief.
9/7/2000.
FIR, my lords may see date and time of FIR 9/7/2019, 22:00 hours.
FIR 22
00 hours.
00 hours. Yes. Yes.
Now your lordship may see the page 21,
Yes.
the seizure list.
Yes.
The reference, my
950.
lords may see. We got PS case 139 dated 9/7/19 under section so and so. Date and hour of seizure is
9:15 p.m.
9:15 p.m.
Yes.
The next seizure list also, my lords, 9:20 p.m., my lords.
And 9:25 p.m. next.
My lords.
Yes. 9:40 p.m.
My
next. Charge sheet here, this.
The charge sheet also I have annexed, my lords.
Yes, Mrs. Jana. First you registered the FIR, then seizure or seizure, then FIR. That is the only case he has.
Your lordship is for several cases for this honorable court. And I would also take instruction whether in the what is the stage of the case. The lordship.
No, your lordship may look at the first page of my brief.
नहीं नहीं आपण दीटा
ସେଇଟା
dispute କରୁने the last put order time coordinate base as the injustice is direct
Same issue.
Same issue.
With due respect, my lords, with regard to that, your lordship may see page 1, my lords.
Anil Sipani.
Yes, yes. Your lordship may look at page 1 of the brief.
Yes, yes.
2417.
Application.
Again.
In page 1,
262 of 2022 was permitted to withdraw liberty from.
your lordship may see what I have stated. The matter out of which this CRLMC application arises
In view of the
was earlier before this honorable court in the present form.
what is the prayer there? The prisoner call for the record. Court below and after hearing both the parties. You are seeking quashing of the entire criminal procedure.
My lords, I do not know what my learned friend has presented to your lordship.
This is 1991.
Yes, if it is 1991, I am asking your lordship to kindly look at the first page of
I'm
the.
there already. I'm there.
Your lordship may kindly look at the
Is
first.
pending and has never been listed in view of the demise of a filing counsel.
Yes,
as
please.
per the instruction of the petitioner.
My lord.
You have read, sir.
Counsel died, my lord.
List this matter along with the present matter along with the CRLMC 1991 of 2020.
There are 3-4 matters are there. It's all along with all the matters.
What are these matters?
That are the.
No, see, but in so far as 262 is concerned, whatever he has written, has
Withdrawn with liberty.
withdrawn to liberty.
And another was withdrawn. Then there are several cases matter, but all cases led.
And what is 2417?
My lord.
2417 also you fight.
2417, I am not sure. No,
Remove the defects. Somebody appear from your office.
Which one?
S. Panda, Land Counsel appearing on behalf of Mr. Devasis Panda, Land Counsel for the petitioner, prays for 1 week time to remove the defects pointed out by SR.
2417 is the matter pending before your lordship.
This is okay. This is okay. Okay. Okay.
ସବୁଟା ଆଶା ଏଠୁ ପ୍ରେୟାର ଥିଲା ଏଥିରେ
ଏସବୁ ଯାକ ଗୋଟେ ଲିଷ୍ଟ କରି ନେକ୍ସଟ ୱିକ୍ କରିଦିଅ ହଁ ନେକ୍ସଟ ୱିକ୍ କର ନେକ୍ସଟ ୱିକ୍ let us see
Let him give me the numbers.
give the
Is it not?
give all the numbers, let us see. Why to confuse? Yes.
Item 3.
My lord, on behalf of BK Behera, kindly pass over, my lord.
Pass over.
Item 3. Yes, ma'am.
4,
My lord. 2-3 weeks for it.
For my lord, this is
My lord.
compromise matter.
My lord.
Item 4.
My lord. This is a compromise matter. Your lordship
This come, my lord, because he has supplied an injury report that indicates the injuries are in the arm, eye and other parts.
Not
I
matter.
also obtained instruction from the IO, whether that is correct or not, because they xerox copy.
Shall I put it next week?
No, someone Anand.
Where are they?
Mother, your lordship fix that.
I will invite them.
No, my lord. Suitable.
You verify. Put a week for it.
Again.
Mother.
You bring them on that day. By that time, he will verify.
item 5.
Lordship, this is for quashing of the proceedings as well as for setting aside the order of rejection of the application for discharge. The alleged offence is under section 13(1)(b) of the Prevention of Corruption Act, section 420 and 120(b) of the Penal Code.
Yes.
The allegation is that, Lordship, the present petitioner was working as the Tahsildar of Dharamshala,
Yes.
Tahsil. And it is stated that two private leaseholders who had taken a Moram mine on lease, they had excavated excess Moram beyond the leasehold area. This is the allegation. The specific allegation against me is that I was a party, as an official, I was a party to the auction process. Despite the auction process being suggested to be stopped by the ADM in an inquiry. What had happened, Lordship, there was a PIL filed in this honorable court regarding the excess mining of the Moram. And this honorable court had directed for an inquiry. And during inquiry, this vigilance case was registered. And it is stated, Lordship, that I was, as the Tahsildar, I took steps for the mining. What has happened, Lordship? The mining, the steps, the authority to hold the mining is the sub-collector, not the Tahsildar. And on the direction of the sub-collector, my predecessor had initiated the process of mining. The bid price was fixed and the notices were invited. So what has happened during the meantime when I joined, I prepared the chart regarding the tenders that had been received. I prepared the chart and put it before the authority, which I was bound to do because my authority had ordered so. And the authority to stop the mining is the state government. The ADM had recommended, but the state government had not stopped the auction. And the second allegation against me is that there is a violation of Rule 56 of the Clause XII of Rule 56 of OMMC rule and Clause 9 of Rule 56 of OMMC rule in not submitting monthly return and annual return to the competent authority and in not erecting and maintaining good condition boundary marks by the leaseholders. This is the allegation. I am not the authority under the OMMC rule. It is the sub-collector who is the authority. This present petitioner is in no way connected to the offence, and there is absolutely no prima facie case against me. Since this has come for the first time, if my learned friend will take instruction, then let him take instruction.
40.
Stated that he is not the authority, he is not duty bound to do that. He is the supervising authority of the field and he is supposed to protect that. Case 42 of the charge sheet, last part.
Investigation further review.
Investigation that overlooking the suggestion of ADM. There was an inquiry by the ADM that illegal mining was illegality in the mining process was detected. Ignoring that, The Tahsildar Dharmasada petitioner has recommended for auction of both the queries, number one, so and so, to the sub-collector Jajpur, conducted an auction on 11/11 without application of mine. Two auction holders, namely Indrajit so and so, with their supporters, have been lifting the excess quantity of morum and holders in Cognizance to the Sankram Kesar Pradhan arrived, Surendranath Biswal arrived, and Ranjan Kumar Jena, Tahsildar Dharmasala, and the present petitioner. And Sri Dhananjay Swami, so and so, sub-collector Jajpur. The auction holder in violation of a clause, clause
56 rules.
Madam, that is,
not
so
submitted
he is, and your lordship, next para you see, the villagers have stated that there was illegal mining without boundary, there is no boundary at all. They have not submitted the required that form. And this petitioner is supposed to supply the LCO there. And he has, the allegation is he in connivance with the, contractors, the auction holder. They had committed the year to the tune of that, in that process to the tune of 1 crore some odd loss has been caused to the government. It's a matter of everything what is there. It's a matter of defense and it can be well tested during course of thorough trial.
Lordship,
Not
1 minute. Just 1 minute, Lordship. The allegation that is leveled in the charge sheet is completely false. The rule will itself point out. I will submit the rules. It is the old rule. I have not brought. On the next
Show me
page.
the rule. If you are not in charge, you have it.
I thought that it is there in the brief. It is not there, Lordship. I will.
List of
Next date, yes. Next date, I will submit the rule. That will sufficient.
Yes.
Your lordship says directly to file the response that I have some personal difficulties.
Okay, let us not Mr. Jena, let comes for this bill submits that to the
Next week.
Next week. His personal difficulty, hence he seeks an adjournment, release the matter after 2 weeks.
1 week after, sorry, 1 week after, your lordship's adjournment petition file that will be.
Yes.
Seven. Your lordship, there are two matters before my lord. My first matter, that is CRLM 3956. My lord, the petitioner was charged sheeted under 341, 294, 506, 34, read with section 31 Roman 10 of the SCST Act. My lord, the discharge petition was filed with the learned court. The discharge petition was turned down by the learned court, against which a revision was been filed. Last occasion when your lordship I pointed out because the revision is pending, the parties now have settled the dispute. If your lordship may kindly have a glance to at page 39.
39?
Madam.
Okay. Yes.
Accused are absent but allowed to be represented on a 317 CRPC for today only.
Third proceeding which I
1924. South upon the special DP Baleshwar. Third, private prosecution is directed to assist the special DP Baleshwar. No status report is filed by the accused petitioner. Petitioner is directed to supply up-to-date status of IN number such and such, awaiting draft of criminal division 65 of 20. Because criminal division, there is a stay by this honorable court. But in fact, if your lordship may kindly turn to page 42 for a moment.
Yes.
The informant appeared personally and filed an affidavit before the special judge Baleshwar, stating that the parties subsequently settled the dispute. Your lordship see the amendments in paragraph 2, 3 and 2 and 3. 2, 3 and the last.
I am appearing for opposite but not to my lord.
You are appearing for?
He is for the revision petition.
I am filing revision with the same petitioners. Got this state. That is criminal division 65 of 2002.
What do you say? Is there a settlement?
So they have instructed him that the matter is settled. Thereafter,
Yeah, the offences are 323 and all. What is SCST and all. Bring them here. I am passing it over.
If your lordship delegate to the, because this is now they have come.
See, I'll tell you, these are not compoundable offences. I have to do it.
Yes, Yes.
So where will I relegate?
No, but if your lordship quashes the charge also, that will also go.
That's right. Why, bring them, I'll quash it here. What is the big deal?
So,
Tomorrow,
Tomorrow, next.
today afternoon, you tell me, bring them and I'll quash it.
There in Bales.
Why are you getting into all these things?
No, my lord.
Online, let them appear.
My lord, can it be on 13th if your lordship may, so that I can bring them online and do?
Not 13th, 15th, huh?
Yes, ma'am.
15th. 15th. You bring them online and quash it, finish it. See, the offenses are 323 and 340.
341 mile.
Bring them.
Because
50.
ultimately nothing will come out from the rest.
I know, he has given the affidavit now.
Yes.
Yes,
Yes.
My lord, in criminal division, entry matter continue till 15th.
Entry mode will continue. Entry mode continue.
It's no instrument.
Yes, yes.
Because there is a
In the
state there.
criminal division, secretary, entry mode to continue. Leave the matter on 15th. Mr. Bose, the counsels appearing for both the parties conjointly submits that the parties have settled their dispute. The informant has already filed an affidavit before the court below to that effect. They seek an adjournment so that on the next date of hearing, the parties would appear before the court and file joint affidavit in that regard. Leave the matter on 15th. File a joint affidavit. Yes.
Oh, bless me.
File the joint affidavit beforehand. Huh?
Yes,
So
ma'am.
that it, yes.
I'm appearing this case.
Yes.
But unnecessarily have been harassed. We are the poor farmers, village people.
What are you seeking here?
Only modification. I don't want to go to the merits of the cause.
Huh?
But the
Modification of what?
cattle has been
Sorry.
directed to be released.
Condition also.
Which is the condition?
That is the page 19C also.
See,
Page 19 impugned order also.
What condition?
Deposit
each cow
200 per
per
day.
day feeding 200 rupees.
Per day.
142 cows.
Who are you?
We are the owner of the cows.
That money you have to deposit.
But this is I don't dispute that I cannot I will not deposit. I will deposit, but it is
I
huge
have
amount.
my own judgment there.
Yes, it is huge amounts. Some reliance may be tangible.
What is the amount?
Altogether, my lord, the
What is the amount you tell me? Just see.
200 and the total amount is 4,89,600.
Where is that? Where have you calculated? Where have you said that?
Because I have stated, my lord, you have 142 cows per day, 200 and 144
So
days.
where have you said that figure? You just give me the figure.
Because day by day it is increased. So till today I have calculated 142 cows per day 200 till date 144 days. So altogether 4,89,600. It's a farmer village people.
You
And
do one
it's
thing.
not-
You do one thing. 50% is deposit and move application
Yes.
before trial court. Deposit 50%, move the application before trial court for variation, and that the application will be decided.
Release by direction he jaise.
The application will be decided on the basis of the judgment by my judgment. That Dhyan Foundation.
Cognizance इटा कला से बोर्ड दो यार चढ़ो.
Dhyan Foundation.
कल टिके कमे दिया तो मैं
50% I did it. What else? 50% I will do. 2 lakh rupees. I am not saying 2 lakh rupees. You deposit 2 lakh rupees, move application, and the trial court will decide on the basis of the Dhyan Foundation.
No, only your lordship, if your lordship directed to deposit 2 lakhs and the cattle.
So you move application, the Dhyan Foundation is not noticed by this court.
Yeah, that is the condition, Malay. That is the
Dhyan
condition.
Foundation, go.
The petitioner shall, as per the prescribed rates by the Animal Welfare Board of India, furnish an amount towards the concepts incurred by the Jimadar for the upkeeping of animals at the rate of rupees 200 per day for each animal since the date of Jima, which shall be payable to the letter before the release of the cattle. So cattle has
See,
been
the idea of this money
Yes.
is not for anything. It has to be utilized for the purpose of the.
Yes.
That is the whole difficult. Who will spend the money then?
No, I am ready to deposit, but it's the excess. It is 200 per day. It's excess because guy can have.
So that is the rule says what to do.
And that is true. So some
You challenge the rule.
amount may be reduced. Your estimate direction.
So 100 per day.
Yes.
50%. That's what I'm saying.
Yes.
50%.
Your estimate direction 100 per day.
50%, right?
Yes. I will deposit.
Petitioner is agreed by
This
the
is my duty. I have to-
stated 29/2024, whereby it is their application, where your application was allowed, na?
Yes, yes, sir.
The application under 457.
457.
457 CRPC for
Set out the BNSS of 503 of BNSS.
BNSS.
Yes, sir.
503 BNSS has been allowed directing the release of 142 seized animals.
Kettles.
Cattles.
Yes.
42 cattles. Cattles. The petitioner is precisely agreed by the condition.
Condition number C.
Condition laid down by the court below under condition number C in the impugn order. C, which reads as under C quarter.
C, page number 19.
Petitioner shall, as per the prescribed rates by the Animal Welfare Board of India, furnish an amount towards the cost incurred by the Jimadar for the upkeeping of the animal at the rate of 200 per day for each animal since the date of Jima, and which shall be payable to the latter before the release of the cattle. Release of the cattle. Okay. Learned Mr. Maharaja, learned counsel for the petitioner. Petitioners submits that although the trial court has noticed the judgment of this court passed in Go Gyan Foundation versus State of Orissa, reported in 2023, live law ORI 20. But the ratio of the judgment has not appropriately applied to the facts of the present case. Facts of the present case. It is apparent from the record that the 142 cattle includes 70 cows, 57 bullocks, and 15 calves. The upper limit rate fixed in the rule, that is 200 rupees per cattle per day, is of a higher side. Therefore, it takes lenience.
Yes.
Regarding head to the contention raised by the counsel for the petitioner in the petition as well as the oral submission, I am of the view that to begin with, the petitioner shall deposit 2 lakh rupees. 2 lakh rupees for the 2 lakh rupees within a period of 10 days. Within a period of 10 days, and on the deposit of the said amount, the cattle's 142 cattle as has been given in Jima shall be released. Insofar as the remaining amounts is concerned, the petitioner is given a liberty to move application for variation of the same. If such application is moved, the same shall be considered in the light of the judgment in Go Gyan Foundation Supra. Go Gyan Foundation Supra. The petitioner, the trial court is directed to the cattle are to be released within 1 week from today. On deposit of rupees 2 lakh. You deposit 2 lakh rupees and take the cattle, so otherwise it will keep on multiplying. The amount will keep on multiplying. You take it, then we will decide.
Yes.
Okay.
Yes.
Give 2 lakh rupees and take the cattle first.
Yes.
Yes. This was the shop.
Yes.
Yes.
And then
This one court had directed further investigation to be completed within 3 months. It has not been done.
Where is that? Instruction regarding this.
15 my calculation. Para 16.
Page 15,
Page 23, rolling page 23.
23.
My lord. Para 16. Government. Instruction number thila. The petitioner's husband was murdered. She wanted completion of the trial because unless
Trial is going on. Trial is going on, as per my instruction.
No, further investigation is completed.
This is the direction of this.
yes.
And we have sent that to Netherlands because that device is, I've stated in losses mechanism.
Yes.
Netherlands, that has not yet come, but that in my final judgment.
So the order was passed.
Final charge is awaiting.
But trial, because this court, this order court is directed to. On the same
Just-
time, the trial will be completed.
Just a minute.
Now,
Where have you said that Netherlands it is
Your
gone?
losses 6 para 6.
For a 6, huh?
Your Lordship, may I produce the order based on which the hard disk has been sent to the Netherlands? I am appearing for the intervention, Your Lordship.
The order was passed.
Submitted to the CD.
Para.
10 units.
Okay.
Located at the Netherlands, to which laboratory the CCTV device has been sent for analysis apart from the other aspects of investigation. Para 10 units.
Yes.
16. The order was passed on 20.
And the IO has also. The IO has also requested the Honorable Court, since correspondence is going on, so most probably within 1 month or 2 months that will come, and 4 months he is requested. Meanwhile, my lord, will submit the.
The order was passed on 27/9/23, granting 3 months. My apprehension, the petitioner is the wife of the deceased who was killed. Trial has been concluded. The PP had submitted a note that he doesn't want to examine any other witness. But they are delaying the matter by doing this. The question is only, if it is further delayed, they may be released on bail. And our apprehension is once they are released on bail, the accused are released on bail.
They are in custody.
In custody for so many years. And once they are released on bail, nobody knows whether they will be punished or not. They will go the punishment or not. Even if
But what, see, without the report from Netherlands, you suggest to file
they are
final.
delaying the matter since 27/9/23, the order was passed granting 3 months.
When have you sent to Netherlands?
That is,
And why they are taking so much of time is not known. It is more than a year.
An instruction.
When have you sent it?
On 19/11/24, Your Lordship. The order is 19. I have provided the order sheet, Your Lordship.
19?
Order sheet is there, Your Lordship.
No intervention petition has been filed.
Lordship, IA number 82 of 25, Your Lordship.
No copy has been given to me.
This is the copy, sir. I filed it today.
What is this?
Your Lordship, I am appearing for the intervener. I am the son, Your Lordship. On my behest, the hard disk was sent to the Netherlands, Your Lordship. Your Lordship has also passed an order in this case, Your Lordship. May I kindly see the petition? This is the case, Your Lordship. I filed the intervention today, Your Lordship. It is numbered 82. This matter was before Your Lordship as well, Your Lordship. I have filed an application for transferring the matter to CBI since the investigation was not going on properly, Your Lordship. Therefore, this court passed an order and accordingly the CID-CV registered an FIR and the technical aspects were taken. First, the evidence was sent to the National Laboratory in Delhi, Your Lordship, but the National Laboratory could not retrieve the evidence, for which I again prayed that the CCTV DVR may be kindly sent to the original OEM, that is Seagate, which produces the hard disk, Your Lordship. And accordingly, based on that,
I passed the order declining you to recall.
Yes, Lordship. In the connected matter, Lordship. In the meanwhile, all these proceedings have been taken place and the trial is nowhere stopped, Your Lordship. Trial is proceeding simultaneously.
No. Trial has been concluded. The PP has submitted a note that he doesn't want to examine any other witness.
That was rejected by the trial court, Your Lordship. That was. I will produce the order.
No, what do you want in this?
I want that early conclusion of the trial, so that they do not.
And 173(8) is open unless it's final charge.
I told you, the order was passed on 27/9/23. They are taking more than a year, 3 months of the
There is
contract.
also a direction in that particular judgment, your lordship, my learned senior can see that on prayer of my,
You must
on
explain
my
what-
prayer also, he can extend the, he can
No,
extend.
you must
extend
explain
the,
on what
type
circum-
of investigation, my.
under
That's
what
also there in that
circumstances you are
order,
getting
Where is that extension?
the judgment right here, your judgment.
See, 27/9/2023, the order was passed.
My
lord.
It was extended further.
It was kind of further investigation be carried preferably within 3 months.
Your lordship, page 24.
24.
My lord.
Yes.
Concluding.
Concluding para. In view of the 23 room se parada pad dujhe. Paragraph 16. In view of the discussion and the principles and so, the court while disposing of the application not being agreed to transfer the investigation so and so, agency to continue further investigation in the matter as far as possible, being alive of the matter, the applicant has shown his concern discussed above, which is otherwise available to the investigating agency under section 173(8) of the code, as against so and so. And of the day, it is the endeavor of all the
Within a period of 3 months.
My lord, preferably within a period of 3 months from the date of receipt of this order, further supplementary report be placed before the learned magistrate in the trial before the concerned trial court. Thereafter, forthwith, which may be considered by the trial court in accordance with law and on its own merit, the trial court to proceed in the case accordingly, allowing the prosecution time, my lord. If so asked,
to comply with the order.
And the
Without prejudice, please.
No,
There is a-
my only concern is
How
that
much time shall I give you? 1 week, one month?
4 months, yes, because your lordships knows Netherlands is not coming, the investigating officer's jurisdiction.
Netherlands is much more efficient than what is in India.
Whenever you send it to the Netherlands, date, tell me date. Tell me the date.
White order 1911, the honorable court order, after 1 week they may have sent. I don't know the exact date, but the order was passed. on
November you have
1911.
sent it. You get me the timeline tomorrow and I'll dispose it up. Tomorrow, exact timeline.
Because IUB training rocha. The WhatsApp raj partition.
When do you want? Next week?
Monday.
Next week, Monday. You give me the timeline, I'll dispose it up. Yes.
Item 11. Item 12.
Where may I please, my lords? My lords, here the order, impugned order, my lord, dated 5/10/2024 is under challenge, my lord. The lordship may come to running page number 53 first.
What is this order?
My lord, this order, my lord, in this case, my lord, I have filed this for challenging the procedural irregularity, my lord. My lord, ex parte hearing of my application under 23(2) was concluded on my lord 3/8/2024. That is at running page number 53, my lord. And the court has placed the matter on to 16/8/2024 for orders, my lord. On that 3/8/2024, the hearing was concluded. And on my lord 16/8/2024, my lord, the opposite party has filed an application for setting aside the ex parte along with the objection to 23(2) application, my lord. 23(2) application, if my lord may permit me, may read the same, my lord.
Tell me what is the
Procedural irregularity, my lord.
Impugned order page?
Impugned order is running page number 54, my lord.
Come to that.
5/10/2024, my lord, last order.
Yes.
The case record is posted today for service of copy and hearing on petition dated 16/8/2024 and 3/8/2024. Learned counsel for both the parties are present. Heard the petition dated 16/8/2024. Respondents were ex parte on dated 18/4/2024 on the very day of posting of order on petition filed by the petitioner under section 23(2) PWDB Act. Learned advocate Shri so-and-so files wakalatnama along with a petition to set aside the ex parte order passed against respondent number 2 to 7 on the ground stated therein. Peruse the same. Learned advocate for the respondent
has submitted in his petition that opposite party number 227 being the parents and relatives of opposite party number 1, my lord, the reason stated there. My lord, after that, merit.
Yes, yes, I'm reading it.
The opposite
What do you
party.
want then? The ex parte order is set aside.
My lord, ex parte order is set aside. My lord, your lordship may just come to running page number 53, order dated 3/8/2024. My lord, on that day, 23/2 application was heard. Last line, my lord, of that order, heard the same, put up on 16/8 for orders, my lord. My lord, 23/2 of PWDV Act talks about, my lord, ex parte order, my lord. If my lord may be.
Yes, yes.
Yes, my lord. So, my lord, hearing was concluded on 3/8/2024 and on 16/8/2024, my lord, the order was supposed to be passed for the 23/2 application, my lord. Without passing any order, my lord, the court has waited for setting aside the ex parte. So that, to that effect, my lord, may I rely.
See, your husband has died.
My lord.
Yes. And they are the mother-in-law and father-in-law.
My lord.
See the age.
My lord. My lord, just the procedural part, my lord.
Forget about the procedure. Come to the point.
My lord, because
what is the relief you are asking in that?
My lord, in that petition, I had asked for recovery of my utilized articles, which were present in the respondent's house, my lord.
Unfortunately, your husband has died.
My lord.
And they lost.
He has committed suicide, my lord.
So that's so this is a pathetic thing, and you are again, complicating the thing.
My lord, the wife
and
is.
This is an emotional trauma for the parents.
My lord, only to
they lost their son.
My lord,
and now you are entangling them in unnecessary litigation. Why don't you finish it up? Why?
My lord, I'm ready and willing to finish
I just
it up.
issue notice. I will not say anything. Settle the dispute. See, you lost your husband. I can.
My lord, I'm ready and willing to settle it, my lord. Just
don't fight on technicality.
My lord,
Come to the point.
Law may be decided, my lord, because this is
forget about the law. What in the matrimonial law dispute? What law?
My lord, once the hearing has been concluded,
because of this law, only the matrimonial disputes are there.
My lord, I'm ready and willing
to. Everybody will be happy.
I'm ready and willing to settle the matter, my lord. My lord may just issue notice.
I'll just issue notice.
Yes, my lord.
I have all sympathy that you lost your husband.
My lord.
He committed suicide. For what reason? Nobody knows.
My lord, the reason that they have filed an FIR, they have lodged an FIR alleging that just because I have filed a case of 498A and the IO has demanded.
And now this is, the reverse things are going on now in India.
And I have been made.
Because of the harassment meted out to the husband by the wife, the husbands are committing suicide. This is now reverse.
No, my lord. There is another point in that suicide note that because of demand of unlawful amount from the IOs, he had committed suicide, my lord.
Whatever, all these things, it is a subject. It is a traumatic thing for the parents also.
My lord.
They see the age of the parents.
My lord, I'm ready and willing to settle, my lord.
I'll just issue notice.
My lord, I'm not praying for any interim order.
Yeah, I'll issue notice, bring them.
Yes, my lord.
If
once that law may be settled, my lord.
Forget about law. Just forget about law in matrimonial dispute. Because of this law only, you keep on fighting on technicality.
My lord.
Simply issue notice, returnable within 2 weeks, file the requisites, bring them, we'll see and try to settle it.
My lord. Issue notice, my lord.
What about the criminal case filed against you?
I'm on anticipatory bail.
Why don't you settle that also and finish it up?
My lord, if they come, then it may be settled.
Let them come. I will send
my lord, notice to opposite party number 3 to 8.
3 onwards.
3 to 8.
Leaving 2.
Leaving 2. My lord, I may make application for adjournment, my lord, during pendency of this.
What is happening there?
My lord, they have appeared and the matter has been, ex parte has been set aside.
That is not in your interest. Let it go on.
My lord.
That is your petition only.
I am
going on. Let it go on. At least. Yes. Okay. Item 13.
13, may I please, my lords? My lords, in this case, impugned order under Annexure 7 is under challenge, my lord.
Yes.
Running page number, my lord, 38.
Yes.
Order dated 29/11/2024, my lord.
What
My lord,
happened here?
this is a case where
125 proceeding.
my lord,
125.
125 proceeding, my lord. I filed the execution case, and my lord, during the pendency of that execution case, my lord, if my lord may I permitted to read the same. Heard on the petition dated 16/5/2024, filed on behalf of the petitioner to strike down the defense of the opposite party due to non-payment of interim maintenance dues. Heard the parties, learned counsel for the opposite party orally objected to the petition, perused the case record along with criminal execution case number so and so, and found that a substantial amount has already been paid by the opposite party husband till date. So the contention of the petitioner wife regarding non-payment of interim maintenance dues has not made it, and thus the petition stands rejected, my lord. My lord, this is a case to which, my lord, I may rely.
How are you agreed by this?
My lord, the outstanding amount of interim maintenance to be paid to me, my lord, is a sum of rupees 2,94,650 rupees, my lord. That has not been paid, my lord. And he's continuing for defense, my lord, for which I have filed the.
You want that his defense should be struck off?
Struck off pendant till payment of outstanding dues, my lord. To that effect, may I rely, my lord, of this honorable court.
Yes.
Govinda Sav, my lord. Relevant paragraph is paragraph 4. There is no provision under section 125 of CRPC for grant of interim maintenance, but still then to have the destitute wife and children from immediate hardship, the Supreme Court and several other high courts have held that interim maintenance can be awarded in their favor. Under this provision, if it is held that 125(3) of CRPC is the only weapon to enforce payment of interim maintenance and nothing else, then the very purpose of introducing interim maintenance would be frustrated. The destitute wife and children would suffer much hardship, and they may not even able to continue the proceeding. The court has power to make his order effective if the order for payment of interim maintenance passed under
the defense is struck off for all times to come.
My lord. My lord,
interim struck off, there is no concept of interim.
I'm not praying for interim struck off, my lord. Here it has categorically stated that till payment of the interim maintenance.
Once he makes the interim,
once he make the payment,
then again his defense is revived.
Yes, my lord.
Where is that?
My lord,
how can it be possible?
My lord, may
once defense is struck off.
My lord, may I continue with that?
Doesn't say that.
If the order for payment of interim maintenance passed under section 125 of CRPC against husband is not complied with, the court
can't strike up for the defense. No.
To
that extent, it's all right.
This view has been forfeited by the decision of Ashraf Ali. My lord, I am relying also on Ashraf Ali.
It's all right. I understood it.
My lord.
It says that it can be struck up.
Yes, my lord.
If you don't pay the interim maintenance,
it
under 125(3), it can be struck up.
That is my opinion.
And how do you say that till he pays? Means once he pays, then what will happen?
No, my lord. My actual prayer in the petition is striking off that.
This is unnecessary. What is the amount?
My lord, amount is 2,94,650.
Where is the interim order?
Impugned order, my lord.
Interim
order, my lord. First, it is in running page number 27. My lord, then it has been subsequently changed in running page number 30, my lord, under an application of 127. And it has been modified to 4,000 and 5,000.
It is the petitioner is the petitioner number 1 is the wife of opposite party, and petitioner number 2 is the son of petitioner is the minor son. They had applied for maintenance under section 125 CRPC. White order dated 5/5/2017 and 20th 20 no, these are spicy. Interim maintenance order was passed. Although the areas have been accumulated, but the opposite party has not made good those areas. Therefore, the petitioner move application on and his application for striking of the defense of the opposite party. By order dated 29/11/2024, the impugn order dated 29/11/2024, the trial court has declined to strike up the defense of the opposite party. Hence, the petitioners are agreed. Mr. Devidatta Mahapatra, then counsel for the petitioner, relied upon the decision of this court passed in criminal revision petition number 373 of 2004, reported in Manu Patra so and relied upon para 4 so. Issue notice to the opposite party written on so.
I, my lord, I have made
What
stay operation, my lord, or I may make a application.
This will not lead you nowhere.
Stay operation of that.
Stay up for the operation of the impediment in the meantime. Okay.
I'm grateful, my lord.
Then you are 125 proceeding is stayed.
My lord, only that order is stayed.
What will you get?
My lord, I have not paid for proceeding, my lord.
Unnecessary going on simple technicality without realizing the ground reality.
My lord,
you are proceeding under 125.
My lord, this
if it is stayed, what will you get?
My lord, that order is, I'm praying for stay of that order, my lord.
Then the interim order maintenance will be there. At the end of the day, whatever maintenance is awarded, he has to pay it.
Yes,
that's all.
My lord, but without paying that, the court is.
Okay, stay. Interim order, stay.
I'm grateful, my lord.
Nothing will happen. Yes.
40.
Yes, sir.
Please, my lord, under section 139, that NI Act is taking cognizance is under challenge, my lord. In the last occasion, my lord, the London magistrate, the way he also proceed with the trial, my lord, may I draw my lordship's attention? How he also, because the accused, so far the opposite parties, he is also residing at Calcutta. So, my lord, only, so since 9/12/2024, my lord, I have applied to obtain a certified copy for which we can also cross-examine the complainant. That certified copy was not available. Thereafter, we also sought for an adjournment. That he has given an adjournment for 2 days and imposed the fine of ₹1,500. My lord, I have calculated since 9/12/2024.
Come to the point.
Sir,
Permission, may I permit to only place only one line? I am appearing on behalf of the opposite party, complainant before the court. Case is posted today for judgment.
Yes.
Trial will be going to conclude today. Even if the day before, yesterday also case was posted before the court. On the ground of pendency of this case, they took time last yesterday.
Because
today case is posted before the court below for judgment.
Sir, only one thing I brought it to my lordship's notice, that is since 9/12/2024 to 7/1/2025, there are altogether, sir, 12 dates. All the dates in between 2 days or one day maximum, because knowing fully well that the accused is residing at Calcutta. So how without getting the certificate, how to cross-examine that complainant? That magistrate knows better. Only magistrate knowing that he is residing at Calcutta, harassing him, adjourning matter either 2 days or only 1 day. And also, in between, he has also imposed the penalty. Though the certificate.
Where from I get all these things? You have not filed anything. How will I get all these things?
Sir, may I pray? Yes.
The proceedings are not there before me. Nothing is there.
Only my prayer is that let the records may call for, then it can be.
Why should I call for the record unless you substantiate a case or 138 case? Why should I call for the record? You file any petition, I'll keep on calling.
Sir, these are the petitions where you sought for an adjournment. And this is that has not been accepted by
Yes, sir, I'll tell you. You have filed a petition. You have to substantiate a case.
Yes.
You can't file a case. Thereafter, you ask the court that collect all annexures for my petition. I can't keep on collecting your annexures. You have to substantiate a case. It is a 138 proceeding.
Sir.
It is a 138 proceeding.
Yes.
So therefore, unless you...
Sir, I have never...
The statute says within 6 months it has to be completed. For what good reason it is not completed, I don't know.
You please see the dates, how the matter stand adjourned. How the matter stand adjourned. He has filed the case on 12/8/2024. Complaint case has been filed 12/8/2024. Concluded on 7/1/2024, 25. In between, there are...
Show me the proceedings so that I can understand exactly if the adjournment is attributable to him.
That is the statement given by me that we obtained that dates. These are the dates. My lord, may I, for my lord's convenience, the matter was posted on 9/12/2024. Again, stand adjourned to that is 11/12/24. Then 13/12/24, 15/12/24, 18/12/24, 28/12/24, 22/12/24. And 24/12/24, 25/12/24, 27/12/24.
I need to know why these matters are adjourned. Show me the proceeding at least.
Lord and Magistrate knows the accused also residing at Calcutta. So we sought for an adjournment at least 1 month or 2 month time may be granted. Number one. Number two, without in absence of the certified copy, how do we?
Are we not wasting time in this process? You don't show me the proceeding. How will I know? Try to appreciate the difficulty of the court also. Unless I see the proceeding,
we will file
why it is written.
Sir, right.
So that is the difficulty.
Are there two?
The matter was again listed 2-3 days back. I told you that file the documents.
Yes.
You didn't file.
No, that's
again the same story.
Sir, these are the documents, sir. These are the documents.
You keep it with you.
No, sorry.
Keep it with you. I told you, I adjourned the matter
no.
to file the documents.
Sir, last occasion it was there because it...
Then I told you to file the documents.
Sir.
I adjourned it. The matter was listed on 3rd of January.
Sir.
It was heard for 20 minutes.
Sir.
I told you, place on record whatever you want.
These are the records, sir. These are the records.
You keep it with you. You will be convicted, then you challenge that. Simply adjourn after 2 weeks. Yes, next. Next.
They only sought a small prayer, my lord, to conclude the trial within a stipulated time, my lord.
Sorry?
My lord.
What do you want?
Conclude the trial, my lord.
Who are you?
I am the one of the But I am the accused.
Are you sure you are accused?
No.
You took 2-3 minutes to decide whether he is accused or
whether accused or informant.
Yes. What are the offences?
All are the offences tribal master, my lord. Offense Cognizance taken 341, 323, 294, 354, 34 IPC.
Yes. You are on bail.
My lord?
You are on bail.
My lord.
So why it should be concluded? Why? Because merely because you approach this.
Your lordship kindly say the last period.
Why preference will be given to your case at the cost of the other cases? You just tell me that. Merely because you could afford to come to the High Court.
Since last 5 years, my lord, pending.
Maybe many cases are there, right? You can't be prioritized merely because you could afford to come to the High Court. There are many people those who are suffering. What?
My lord, PW 1 and 2 has already been examined and questioned on the year
I understand
2022, my lord. After 22 to till date, other witnesses have charge sheeted witnesses have not been examined, my lord. Till date,
you accept the proceeding of the court below. You have not filed anything. How many witnesses are there? I don't know. How many witnesses are there? Charge sheeted witnesses. You have not filed charge sheet except the proceedings before the court below.
You kindly see the last order sheet, my lord.
You tell me how many charge sheeted witnesses. Do you have any idea?
My lord.
In the petition also you have not said. When the charge sheet was filed, how many
Madam,
witnesses are there? Huh?
5 charge sheeted witness.
Where have you seen that?
And I have also a copy, my lord, with me, my lord. Any dead picture I am providing.
No. Right, petitioner in this petition is seeking a direction to the trial court, namely the SDGM Kedrapada, to conclude the trial within a specific period. Conclude the trial in which case? Conclude the trial in GR case number 1482 of 2019 within a stipulated time frame. Except to the proceeding for the court below, no other documents are attached with the petition. Therefore, it is difficult to ascertain how many witnesses are how many charge sheeted witnesses are intended to be examined by the prosecution, and what is the nature of the trial, etc. Nature of the allegation, etc. Be that as it may, the prayer made by the petitioner deserves merit because the petitioner, being an accused, has a constitutional and a statutory right of free, fair, and speedy trial. Therefore, it is expected that the trial court shall do well to see that the trial is concluded as expeditiously as possible. That's all. Yes, next.
Disposal.
Yes.
16. May I be similar? Vigilance conviction of Miller. 4 years. That is running page 61.
4 years.
4 years, Miller, for commission.
Are you on bail or
bail? During trial, I was.
appeal admitted? The format of appeal admitted. The bail granted. Realization of fine. The option for realization of fines.
Sir,
Call for TRC. Yes.
the appearance of Mr. Sanjay Kumar Das.
Mr. Sanjay Kumar Das entered appearance, except notice and entered appearance on behalf of the witness.
The realization of fine and sub item also another.
Sub item, both these. Both these.
3 copy with 1. 17.
May I please, Julius? Challenging the order dated 28/9/2024. 28/9/2024, my lord. Filed by the Lord Special Judge Vigilance. But the petition filed for the discharge petition, my lord, that has been rejected, my lord. The allegation is under section 7 of the PC Act, my lord. Present petition is the clerk in the office of the SI Superintendent, my lord. Allegation is that out of 5 licenses, 4 licenses have been released in favor of the license. One has not given. So for which allegation that he has demanded for 5,000 rupees, and that has been taken and it was held. Thereafter, the licensing issuing authority is the superintendent of excise, my lord. Absolutely, there is no nexus with the present petitioner with regard to the issuance of the license.
Yes.
Only he has to hand over license.
Let us come to the charge sheet. What are they?
My lord.
31. Yes. Thereafter, Dhruva Charan Malik. You are reading that?
Bottom. That's the question.
3rd paragraph. Copy of preparation report. On being asked.
The superintendents allowed it to access this.
On being asked, the accused Behra clerk produced the following relevant document from his possession, which was seized from him in presence of the witnesses and released, so and so.
Page 28.
28.
Page 24. He is the in charge head clerk, the superintendent excise board.
Yes.
The complainant filed an application for renewal of his 5 foreign liquor shop notes. And on 1st August 2019, notes that the complainant and the accused one, they also went to the superintendent office. Superintendent office asked, after going to the license, superintendent of police put his signature on his 5 separate license and then hand over to Behra, the petitioner for lordship.
You are Ranjit Kumar Behra.
Yes.
Specific allegations are there. On 1/8/2019, he met with Ranjit Kumar Behra, dealing clerk in his office, who printed out the license form from the computer. Then he, along with the complainant, Sri Mahapatra, went to the office room of the excise superintendent, Cuttack, and after going through the license, the excise superintendent put his signature in his 5 separate licenses and handed over to Mr. Behra, and with the instruction to issue the same to the complainant. Keeping in the acknowledgement, Mr. Behra clerk came to his chair and demanded bribe of 5,000. When the complainant Mahapatra told that he has come with the money, Sri Behra handed over the license number so and so, keeping the receipt, and told him that when the complainant will pay 5,000, then another license will be issued to him.
Unless
What else you need?
Unless it is signed by the competent.
All these things will be evaluated.
It cannot be handed over to the
No,
person concerned.
No, specifically.
It is, there is a delay in signing by the competent authority.
Can I go into all these things? What circumstances?
And only
there is a demand, there is a acceptance.
What is the role of
All the grounds, my lord.
what is the role of the present petitioner?
I don't know, because there is a specific allegation of demand, there is a specific allegation, and you have to accept it.
That's what we have made out a case against the BBK. Absolutely,
they will prove it. That is their problem. That's their problem.
That is absolutely
the allegation of demand is there.
No, that is the allegation.
And 5,000 you are taking, and it was trapped. And phenolphthalein test is
changed. These are the allegations. But the prima facie, the lordship can say who is the issue the license.
No, that is the only ground he has taken.
That's not the test.
My learned friend has conducted number of cases. That's why I'm placing paragraph.
Therefore, he is mildly placing it. He knows.
No, my lord, section 7.
He is not. See the.
Still to refresh his memory, I'm placing one line. My lord.
You need not do that. See his body language. He knows his case.
No, body language is very positive, but I appreciate his persuasion.
Only my submission.
Holding a difficult brief, what to do.
And with a flash of smile, but the illustration appended to section 7 is
the role of the present petitioner, because he is not the issuing.
Why sat about the matters only to get the money?
Unless it is signed by the competent.
Why have you accepted 5,000?
No. I have
then
not.
I request record from you. They have recovered from you.
But they have given the money.
Then section 20, rebuttable presumption.
Recovered from you. Hands with the color.
You need to write all these things.
Even asking is good enough for 7. Even asking.
The moment you accept, presumption operates against you, which is rebuttable. Face the trial and get it rebutted.
They have put on the table, my lord.
Table.
Yes,
he kept in the left hand and the right pocket.
That was
and he kept in his left side front pocket by the left hand. Page 30 minutes.
Where is the question?
It was not table. Why it was never thrusted upon. It was never thrusted on. Gladly he accepted. And what he did, and my lords, he kept in his left hand, left side pocket, pant pocket by the left hands.
Yes.
And that's turned to be pink color, my lords.
Absolutely. Pass an order.
My friends knows, my lords.
Keep it open. You argue unnecessary. Why to invite some finding?
May I claim?
Yes.
Let it come next week so that I will take instruction.
Sorry?
Next week, let it come next week. I will take instruction. It will
not improve.
You tell me what best I can give you in this petition.
Material instruction. Then
leaving apart the discharge part, what best I can give you in this petition. You tell me if it is feasible, I can give you. And he will also not oppose.
Only question my grievance is that I don't have any role with regard to that. That is the one.
I'll pass the appropriate order.
No, that will affect you.
That's what I'm saying. So you tell me what.
That is why I'm saying that next week, so that I will take instruction.
Friday.
My right. Oblige.
You just tell me what best I can give you in this petition. Leaving discharge. Okay. You are working as what? You are working as
judge clerk.
Clerk, my
in the excise so but that's.
You are on bail. Are you on bail or not? Bail has been granted to you? Bail has been granted. Yes. 18. Yes, sir.
May I please, your lordship?
Yes.
I am also on discharge, your lordship. The discharge application was rejected by the Lord and Special Judge Bhubaneswar.
Yes.
Your Lordship will find at Annexure 7.
Annex 7?
Annexure 7, Your Lordship.
Okay.
Page 326.
Yes.
Order dated 19/1/2020.
Yes, I'm there.
My Lord. 326. My Lord, the complaint was, my Lord, lodged by the opposite party under Annexure 1.
Yes.
Your Lordship may kindly see for a moment, that is the number, page 19. Facts leading to the complaint as per FIR number, complaint number, police report under section 173(2) of CRPC, nature of civil offences and place court where it is being tried. The offence, my Lord, your allegation, Your Lordship will find at page 20.
Yes.
Second paragraph.
Yes.
During the course of the proceeding, the detainee Sri Rajanikanth Patnaik voluntarily, my Lord, Rajanikanth Patnaik, FIR was registered against Rajanikanth Patnaik. Name of the petitioner was not found in the FIR. No allegation was made against the petitioner in the FIR. There is no specification, no allegation, nothing.
In the schedule of?
In the schedule of offence. But what has happened? Charge sheet was filed only on the statement of Rajanikanth Patnaik, because opium, gold, other articles, ganja, were seized from the exclusive possession of Rajanikanth Patnaik.
Right.
FIR was registered against him. Investigation was carried. He made a statement during FIR, but Your Lordship, that is the statement. Your Lordship may kindly come to page 20.
Yes. On the basis of which you have been implicated there?
I have been implicated only on the basis of the statement of Rajanikanth Patnaik, nothing more. And the Rajanikanth Patnaik made a statement before the police, and the witnesses who were present before the police during investigation, their statements were recorded saying that we
That's
were
good enough for the purpose of getting bail in that case.
I have been released on bail by that.
To that extent, that can help you.
No, that much bail has been granted.
Yes.
And also I am under the 88 CRPC benefit before the trial court in PMLA.
Yes.
And here, my Lord, Your Lordship may kindly see this second paragraph. During the course of the proceeding, the detainee Sri Rajanikanth Patnaik voluntarily disclosed that he had procured the contraband ganja from Bapi Diggle, Ajay Diggle, and F. Patnaik, and others of Baliguda, Kandhamal.
Yes.
But those persons have not been made accused in the either in the schedule offences or in PMLA. However, he could not provide any satisfactory answer towards the possession of such huge contraband ganja, opium, and cash and gold, and gave a prevaricating statement.
Yes.
But here, my Lord, the present petitioner's name was not there, and he has not also given a satisfactory answer regarding possession of opium, wherefrom he has brought. It is the specific, my Lord, allegation here.
See, unless, I'll tell you, we are not need not waste time. Unless you are discharged or acquitted in the schedule offense, you are not going to get any benefit of it. I am not going to get into the merits of the schedule offense. Fact remains that there is a schedule offense which is registered against you. Whether the schedule offense merit is there, merit is not there, is none of the business of
PMLA I have
court.
taken a ground.
PMLA court only can see if you are discharged in the schedule offense or you are acquitted in the schedule offense. Then I can go into those findings and all.
My Lord,
And fact remains, there is a schedule offense against you. Wrong, right, whatever.
Yes.
So therefore, 45 under PMLA is maintainable. Let us see PMLA 45. What is the allegation against you and how it is proceeded?
Yes.
Come to the 45.
I will take to that, Lordship, only to my Lord answer to your Lordship's query that whenever schedule offense is concerned, my Lord.
Can I go into the merit of a schedule offense at this stage?
I have taken a ground.
But that's not the law. Why should I waste time?
Offense is made out. My Lord, your Lordship.
That's not the law. Law is only see 45. Schedule offense is there. Now come to the 45.
My Lord.
See the 45 what they
My
say.
Lord, your Lordship may kindly see for it.
Come to 19, page 19.
Schedule offense, my Lord, the trial is not proceeding. And in PMLA Act
that
also,
is not the consideration.
In PMLA Act also, there is a procedure that both the cases will be tried to by a same court. There is a procedure in
Come, you have moved an application for discharge in this case, which has been turned down. Let us come to the 45 petition.
Exactly.
Page 19.
Page?
Page 19, 19.
One.
Kindly see that. Straight away, Lordship, kindly see page 21.
No, page.
I need not go into anything else.
Yes.
Page 21.
7-4. Your Lordship may kindly come to page 7.
Police station against the accused is Rajnikant Patnaik, son of so and so, for alleged commission of offence under section 18B, 20B, 2C, 25, 29 of the NDPS Act. Subsequently, the Khalipur police station filed a report under the section 173 CRPC, charge sheet number 2 so and so before Honorable Special Judge and additional so and so. Now you also may turn to the charge sheet reveals that Rajnikant Patnaik disclosed that he had procured the contraband ganja. The quantity your lordship will get at page 20 top. How much ganja and what has been seized.
I am no concerned with ganja. I am no way concerned with ganja.
Ganja from different distributors like Sri so and so, so and so, so and so. Kandhamal and opium from one Kabimani Maharana, this present petitioner. Owner of Mr. Vishwakarma Ayurvedic Private Way for past 10 years. And kept them inside the plastic bags for the purpose of selling, transporting, according to Rajnikant Patnaik was arrested. Then your lordship, next. The charge sheet reveals that since Rajnikant Patnaik habitually procuring opium from the said Sri Kabimani Maharana, this petitioner below. Police conducted search operation on 24/10/21 in the residence of Kabimani Maharana, whereby Sri Kabimani admitted to have procured opium from government opium.
Yes. Yes.
So and so.
After this, what do you have?
Your Lordship may kindly see for a moment to answer my learned friend. But Kabimanu Maharana has a valid license. He is procuring the opium from the government, from the central government, for the purpose of medicinal use. Because he has a license.
All these things are your defense.
My lord?
All these things are your defense. You have established that.
Just my lord, I am establishing that. How?
You have to show the inventory. This is what I have procured from government license. This is what I.
Yes, I have shown.
All these things are.
I have shown. My lord, I have shown. I have annexed it before lordship. I have annexed it, and that is the case.
My complaint shows below. He has not kept any record where you utilize it. Rather, after search.
My lord, deliberately they have not done this. I have annexed it.
But why should I go into all these things?
I have annexed it on the annexer 4 series, your lordships. That is the procurement and utilization. And
then I have to then actually conduct a trial then.
Your lordship may kindly see, your lordship will be understood, my lord, by saying the 176. Your lordship may kindly see what statement that Rajnikant Patnaik was given before the police. Your lordship may kindly see for a moment. Page 176. But they have derived it in different way. Your lordship may kindly see 176. Page 176. Your lordship may kindly see.
For his satisfaction, let him.
Yes, your lordship. Your lordship may kindly see 176. That they said that from the license they are taking away. That is not the correct statement. Your lordship may kindly see.
I am there.
ମୋର ନାମ ରଜନୀକାନ୍ତ ପଟ୍ଟନାୟକ ପିତା ମୃତ ସଚାନ ସଚ ଖଲପଡା ଗଞ୍ଜାମ ଏତେ ରିଖରେ ଖଲିକୋଟ ଥାନା ପୋଲିସ ଦ୍ୱାରା ଅଟକ ହୋଇ ତାଙ୍କ ହେପାଜତରେ ଥାଇ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ସ୍ୱଇଚ୍ଛାରେ ଦେବା ମୋର ଅବିକଳ ଜମାନବନ୍ଦୀ ହେଇକି ଯେ ମୁଁ ଗତ ବର୍ଷ ପ୍ରାୟ 20 ବର୍ଷ ହେବ ଗଞ୍ଜେଇ ବେପାର ଏବଂ 10 ବର୍ଷ ହେବ ଅଫିମ ବେପାର କରି ଆସୁଅଛି। କବିମନୁ ମହାରଣା ପିତା ମୃତ ଦଣ୍ଡପାଣି ମହାରଣା ଗ୍ରାମ ଧରାକୋଟ ସାହି ଖଲିକୋଟ ଥାନା ଖଲିକୋଟ ଯାହାର କି ଗୋଟିଏ ବିଶ୍ୱକର୍ମା ଆୟୁର୍ବେଦିକ ନାମକ ଏକ ଫାର୍ମ ଅଛି ଯେଉଁଥିରେ ସେ ଲାଇସେନ୍ସରେ ଅଫିମ ଆଣି ମେଡିସିନ ତିଆରି କରୁଛନ୍ତି। ଅଫିମ ଲାଇସେନ୍ସ ବ୍ୟତୀତ ଅଧିକ ଅଫିମ ଆଣି ସେମାନେ ଲାଇସେନ୍ସ କଥା କହୁନ ଏମାନେ ପିଏମଏଲ ରେ କହୁଛନ୍ତି ଲାଇସେନ୍ସ ଅଫିମ ଆଣିକି ଦେଇଛନ୍ତି।
Sir, can I appreciate 161 statement and decide the case at this stage?
On the basis of this, my lord, I have been made accused. And PML complaint is lodged. The license of opium obtained using that license is being utilized and it is being given to this. So this is the difference. You are kindly say 7 point. My lord, why I am harping this? You lordship may kindly come to 7.4 the complaint. You lordship will find out this.
Yes.
Page
Yes.
30.
30. Yes.
7.4. So
Yes.
what is the allegation whenever section 3 of PML Act is concerned?
Yes, yes.
Further, during the course of investigation under PMLA 2002, analysis of bank account statements held in the name of Sri Kabimanu Maharana, Mrs. Vishwakarma Ayurvedic Private Limited revealed huge credit to the tune of such and such, out of which such are cash deposits during the year 2014, 15, 2020 and 21. However, scrutiny of copy of ITRs submitted by Sri Kabimanu Maharana revealed gross income only to the tune of such for the aforesaid period, that the aforesaid acts reveal that the credit transaction reflected in bank accounts of Sri Kabimanu Maharana do not match with gross income annual shown by the annual income shown by him in his tired ITR during the same time period. Hence the huge cash deposit. This is the conclusion. So though it doesn't match, therefore I have brought from
That is what the jurisdiction of PMLA.
My lord,
whether the proceeds of crime is there or not, that is the investigation.
my lord, no,
That's what
my lord, the evidence must be that from what is the connection with the
let them lead the evidence first. They have not lost the evidence.
visualize one thing. But there is no monetary transaction. There is nothing to show that there is a monetary transaction of that Rajinikanth Patnaik.
They say this money is crime proceed, according to them.
Where from I will get
it? It is onus on them to prove that.
Line of his own statement recorded under section 50, your lordship knows statement recorded under section 50 is like 161.
Yes.
Your lordship time
Like 108 of Customs Act.
Yes.
Yes.
Page 44 below.
44.
Yes, below.
Yes.
He himself what he has stated. Sri, page 44, paragraph 7.8.
Yes.
Sri Kabimanu Maharana was examined on so and so. That he is a businessman doing business manufacturing Ayurvedic medicine to so and so. He provides contractors a petty proof concept for which he earns 40 to 50,000 per month. Your lordship has seen, my friend, 3 crore cash was deposited in his account from where he got. That this is money laundering. And the next line, next page, we have given detail.
The total he has not read.
No.
46 top.
Yes.
He knows Rajinikanth Patnaik, as he used to purchase fertilizer from him, that he had never sold him any opium illegally. He was arrested by police so and so. Then he himself admitted.
This is 50 statement.
Yes.
What to do?
What is that, Malcolm?
50.
Section 50.
50 statement.
But he has
It is not 161 statement.
No, it is
50
section
statement.
50. He has not admitted
And
that
it
he
is
has,
into 108 statement.
my lord, he has not
It's
stated.
very dangerous statement.
My lord, your lordship may kindly visualize. I am reading that 50 section 50 statement. He has not stated that
I will not analyze all these things at this.
I am involved in that civil offense.
Okay, I pass the order. Okay.
Your lordship may kindly see for a moment.
I pass the order. I'll read it. I'll pass the order. But that may create problem for you.
Yes.
I have to give a problem.
My lord, I have to either, or then if it will create problem, my lord, being of my
create
client,
problem in this
welcome to the problem to my client.
No. I'm not saying that to create problem in this sense. I have to dwell upon the merits of the case. Then some observation. I'll craft in such a manner that it will not prejudice you.
No. Your lordship.
Investigation is faulty, then also he cannot be discharged.
Your lordship may keep it pending to this case to some other law.
No, because on this ground he is taking time.
No, I will not take time. My lord, charge will be framed today. My lord.
Special court has called me. He was very unhappy because of this case. He shouted misbehavior.
My lord, charge will be framed. My lord, my lord and friend was not present on that time. No, I am not an unfair counsel. I am not at all an unfair counsel. I don't. My lord, your lordship may kindly peruse one thing. Today.
No. If I'll keep it pending, what will happen?
My lord, what will happen? My lord, just answer. But that.
What benefit are you going to get?
My lord, I will get that benefit. My lord, the date is fixed above in respect of the schedule offence for framing of charge.
Yes.
So I will file one application under section 227 there. If my lord that will be rejected, I will file that application here. So both will be tagged together, will be hard.
See, I'll tell you at any stage, if you are discharged in the schedule offence, these cases will be dropped.
It will be dropped.
So therefore, you do it. Let it go on. How does it make difference?
Recently, Supreme Court has said, if it is discharged, then the PMLA Act will be discharged.
Well, that's what I'm saying. You try there. If you are discharged, very good.
So therefore,
your
lordship may kindly visualize. Today, the date is fixed for framing of charge. And the trial court has specifically stated that I will not adjourn it unless only you show the. I will admit before the trial court, they frame the charge. No problem. I will not file any application to get the benefit of this case. I do undertake before this honor. Your lordship may keep it pending.
Friday.
Yes. So that
Friday, let the charge be framed. Friday.
Charge be framed.
Friday.
No problem.
Friday. Huh? Monday. Let the charge be framed. and make it clear that on the pretext of pendency of this
No, I
petition,
will
you
not
can't
file any application.
get the benefit out of
Rather,
it.
I will ask to the law and tribunal to frame the charge. I have called up.
Shall I clarify?
No, no, why? Well, I will, your lordship, my learned friend will say whether I have taken the benefit out of the.
No, because unnecessary these matters are pending. There is no point.
No, ma'am,
Trial
my
court has
charge will
specifically
be-
passed order,
Hmm.
unless you get and stay order, I will frame. the
Definitely,
charge.
my lord, court has
For
said,
that
court has
reason, the
said.
court
Then
has
Monday
Court
by
has said like.
by Monday you. Thank you.
20.
The Belgium matter.
Yes. Yes, madam.
NBW has been issued 19/7/2024.
24.
Yes,
Bail?
they are released on bail 23/7/2021. Two petitioners are there.
Two petitioners, 500 each. Okay. Next.
21.
Bail was granted on 29/6/2023. NBW issued on 24/10/2024.
24.
Well,
Okay. 500 each. Two
Well,
petitioners.
local
500 each. Okay.
local
Next.
law.
Local law.
22.
22 lordship, NBW issued on 1/11/2024 at page 15.
Bail?
Bail 11/12/2017.
11, 12, 2017, 24. Okay. 500. Okay.
23.
Local bar record. Local bar record. Yes. Withdraw. 23 withdraw. Yes. 24 also. Withdraw. Yes. 23rd, 23 withdraw. And 24 also withdraw. Yes.
25.
Yes, sir. 24.
Petitioner.
Custodies.
CDS.
It has been filed since long while. Taking time, your lordship knows that. Second time. Second time, one of the they have been granted bail. Technically 395.
CD, awaiting CD, good week for us. Yeah.
Next week.
Next week. Next week. Yes. 26. Yes, Mr. Sao.
Custody since 9/11/2023, my lord.
9/11.
Yes, my lord.
Okay.
23.
Yes.
The age of the lady is 29 years. Assurance to marry, kept relation.
She is lady?
Yes, my lord.
Joginder, no. Victim is a lady.
Victim is a lady.
Okay. Yes.
In the meantime, charge sheet submitted, my lord.
376-2N.
Yes, my lord.
Yes. What are the 164? Just reading.
160.
Victim under section 164 CRPC has been recorded. Reading of the statement for the victim prosecutors reveals that the victim has developed a relationship with the present petitioner, and during their courtship, some photographs were taken by the alleged to have been taken by the petitioner, and the same was viral, alleged to be viral. And the petitioner, the victim is a married woman. The FIR was registered on
8/11/23.
On 9/11/2023, the petitioner was subjected to medical examination. The medical reports, the opinion of the doctor in the medical evidence reads as an petitioner is in custody since 9/11/2023. Regarding head to the nature of acquisition and the fact that the petitioner is in custody since 9/11/2023, the affidavit has been filed. The prosecutrix admittedly had been in relationship with the petitioner. I am inclined to enlarge the petitioner on bail accordingly granted bail. Yes, next.
Oblige.
27.
Yes.
This is the modification of order also.
Modification of which order?
Order dated 7/11/2024.
7/11.
So that in that case, one CC case has been mentioned 123/2019. After the case is committed in Reliance Sections Code, is renumbered as that is the ST number 215/2024.
Where is the IA number?
IA number
1533.
That is
For
5A.
the reasons stated in the application, the same is allowed and correction carried out. Correction. Okay. Correction carried out. Yes.
28.
May I please, Your Lordship? Your Lordship granted bail. I have annexed of. He could not be able to avail that order. Page 14 of my brief.
Where is the bail?
Page 14 of my brief.
14.
Page 14.
Yes.
Page 17, your lordship statement come to page 17.
17, huh?
17, clause number 6, he shall be released subject to verification of similar types of antecedent, if any.
Yes.
But unfortunately, that has been found that a case has been instituted against him. Last occasion also I have submitted before lordship by the NCB at Calcutta. No summon, nothing else, not a single notice. And while this case has been, I have produced the certificate, that time the excise staff, while inquired about the matter, they could be able to trace out.
And you have ascertained? Yes. What is the next registered against him?
Yes, sir.
Where is that?
One page in front of us.
NCB cases are very serious cases.
My lord, can I submit before you? In Khordha, one NCB case has been instituted, that is 60 kg. I have contacted that case. That is in respect of the NCB is to be initiated. International.
Already been issued by the government.
If their NBW has been issued, go and avail. Even if I alter this, makes no sense. Better would be go and try and get bail there. You are already there in bail in this matter.
For that reason, my lord, can I submit before also? I may be released.
You do one thing. You withdraw it right now and pursue the remedy, because even if it is granted, you can't come out. So the custody will be counted. Don't do it. Rather you try and get bail there. That's a better idea. And the modification can be done anytime.
No, I say release I can approach before the Calcutta High Court.
You will be taken into custody in that case.
Till today, no.
See the instruction.
No instruction.
I am suggesting you a better course.
But no production.
I am suggesting you a better course. I will tell you.
My lord, that is
better
true.
Course. So this custody will be counted towards your sentence.
Till today, I have ascertained from the conducting lawyer, till today, no production warrant has been produced by
NBW has been issued, you have to inform. I'll record it and dispose it up.
Can I pray before your lordship?
Yes.
Otherwise,
better course I am telling you. Right on. Petitioner in this petition is seeking modification for the order dated 4/10/2024, whereby this court, although granted enlarged the petitioner on bail, however, with a condition that subject to verification for similar antecedent, he would be released. When he approached the court below, it revealed that there is a NCB, Narcotic Bureau or Narcotic Control Bureau of Calcutta Journal has already registered a case against the petitioner. Therefore, the petitioner was not released on bail. Notice was issued to the State Council, and who inter alia has obtained instruction which reads agenda. In view of the state instructions, Mr. Das, and counsel for the petitioner, at this stage seeks to withdraw the present petition to avail remedy under law. The application is disposed of at this stage.
Giving liberty.
I have disposed it up. Once you get that bail, you come and move application. I will release it immediately. Release order is already there.
Can I before I'll check that instruction copy one?
I am reproducing that in the order itself, so that it will be easier for you. I am reproducing. So therefore, I am making it part of the order. Okay.
Obliged.
Because this bail order is already there. Once you get that bail, you move an application, it will be modified. Yes.
29.
In the case of 302, the petitioner will custody since near about 5 years inside the custody.
5 years.
Near about 5 years.
So going to
custody.
The main eyewitness in this case, one is Kumar Nair, who has already died since 2022 in a road accident.
Who?
Eyewitness.
Only eyewitness to the occurrence.
In the meantime,
Custody period, you tell me.
Custody.
1 minute. Custody.
19/2/20 lordship.
19/2/20.
Yes.
Yes, tell me.
Material witness, your eyewitness Kumar Naik is already been expired due to road accident, Your Lordship.
Kumar Naik, huh?
Yes, Your Lordship. From the bare period, the impugn order, Lordship, the London Trial Court has clearly hold that though the eyewitness has been died, there are other material witnesses already been examined, Your Lordship. That copy is not with me, Your Lordship. Those who have the material witnesses already been examined before the London Trial Court, Your Lordship.
Do you have that? Do you have that copy?
Material witnesses, those who are examined.
Place it on record. Just see, have they supported the prosecution?
No, so they have stated that they have heard the incident from one Kumar Naik, who is
Kumar Naik, who has died.
Died.
Where is that? Read it.
PW 5 Lordship kindly answer. PW 4 Lordship.
Yes.
I am the informant of the case.
What is your name?
Paragraph 3 Lordship.
Your name is Santosh.
Santosh Nag Lordship. In paragraph 3 of PW 4 Lordship. Where the relevant
Annexure, sorry, PW?
PW 4 Lordship.
4. Yes. Yes. Yes.
Paragraph 3 Lordship.
Read it.
Lordship. At the relevant time after taking dinner, we all family members were
Para
going
4.
Paragraph 3 Lordship.
3, okay. At the relevant time for taking dinner, all the family members were going to sleep. Kumar Naik. Who is Kumar Naik?
Lordship.
Kumar Naik.
He is the eyewitness to the occurrence and he expired in the meantime.
And inform us that while he was returning from the disease on cycle, the accused restrained him, canal activities from so as well as the disease and so on the part of the body so. He has heard it from Kumar.
Kumar.
And what about the other witness?
All of the all family members they after reached in the spot and they have started like this. Lordship.
With disease was returning from so. In fact, I have stated him for the police also.
And some were also turned hostile.
Working at that time on the road for near Culvert between also the accused came from which had by means of wooden plank and for which the fell down the ground thereafter the accused dealt successful blow to them like that. That the wife of the deceased and other shifted the. Where is the statement of the wife of the deceased?
Wife of the deceased PW4 Lordship.
PW4.
Yes, Your Lordship.
Okay. Wife of the deceased and others, huh?
Yes.
And what we see, just see the PW2. PW2 has stated.
They are turned hostile. Lordship.
Huh?
1 and 2 turned hostile.
1 and 2 turn hostile.
Lordship.
And 3?
3 also Lordship.
3 also hostile.
Lordship.
Yes. What do you say?
But fact is, Bandha Naik is the wife of the deceased, Your Lordship. He has stated in the deposition that in the
heard from
Kumar Naik has stated that
he is the sole eyewitness.
Yes, so Kumar Naik is the sole eyewitness. But
Then
no more. Now he is no more.
I'll grant you.
Yes, Your Lordship.
I'll grant. But petitioner is accused in so case. Okay. Allegation is the petitioner so. The counsel for the state submits that 4 witnesses, vital witnesses, have already been examined in the present case. However, the sole eyewitness, Kumar Naik, has died on
25/12/2020 due to road accident.
Due to road accident. Road accident, is there anything to do with?
Yes, is there.
No. Is there anything to do with this accused?
No, another case.
Sure?
Yes, yes.
Okay.
That's important with me.
Therefore, the eyewitness, the evidence of eyewitness could not be recorded. The certified copy of the evidence of PW1 to 4 has been handed over during the course of hearing. PW4 is the wife of the deceased. And he died, huh? Died. Mr. Mohanty has placed on record the instruction, written instruction dated 10/12/2024 in that regard, which reads as the instruction. Four vital witnesses have already been examined. PW4 is the wife of the deceased. Who in her statement before the examination chief has stated as under para 3. para 3 PW4. Okay, para 3 PW4. According to her, it is only the eyewitness Kumar Naik, since this has witnessed the occurrence, and all other witnesses are the hearsay witness. Hearsay witness. Out of them, 2 witnesses, namely PW1, 2, and 3 also.
No,
1, 2, and 3. No, 1 and 2, witness 1 and 2 have turned hostile and resigned from their earlier statement. Insofar as PW3, 8 witnesses examined, not 8 witnesses, total 8 witnesses. PW3 and other witnesses are concerned. None of them have implicated, none of them have stated anything having direct knowledge regarding the occurrence. PW6, the PW5 and 6 are post-occurrence witnesses. Post-occurrence witnesses. The what is the stage of the trial now?
Trial continuing.
Or the trial of the case is still continuing. The petitioner is in custody since 19/2/2020. Regarding head to the period of custody of the petitioner for about 5 years, since 19/2/2020, and the nature of evidence which has come on record, and taking into consideration the fact that the sole eyewitness in the present case is not available to be examined, I am up for the considered review that the petitioner is entitled to bail. Public law, he has to appear in the court and that.
Yes.
31.
Yes.
No, kindly permit to withdraw, madam.
Withdraw.
I guess.
Yes.
32.
Item 32, 33, I'm appearing for the opposite parties. This is a review application at the instance of.
Yes.
With due respect, I submit before your lordship that previously the similar matter, the lordship had and gave the order for discharge.
Reserve.
Yes. This is on the same ground. No, my ground I just submit. Whether that question was raised or not. This is on the ground of delay, the FAO was dismissed. That may be a little bit different. I want to raise some question here. Sir, this is a appeal out of the review application has been filed. Appeal under section 24C of the Orissa Education Act. The order was passed by the tribunal.
No, if the appeal is dismissed on the ground of delay, where is the question of review?
That is exactly my
as simple as that. Why should we get into all this thing?
Your lordship, that.
I'll dismiss the review.
Yes.
If the appeal is dismissed on the ground of review, you go somewhere else, not here. How can you file a review? There is order 47, coming under any exception of order 47?
You cannot. That doesn't create.
This is the only question.
Right, sir. Yes, sir.
Oh, that's it.
Now, since the matter has already been. These two matters, 31.
2 matters. Yes.
Whether
But
that question
let us see the impugn order.
You also look to that.
Let us see the impugn order, but it shouldn't be.
The review application.
This is the annexure 2.
Yes.
Annexure 1, it seems.
Annexure 1, just did us.
In many cases, you have gone to Supreme Court.
Yes.
In few cases, you file review. What is this?
And the ground of review?
No, granting it. I myself have done many SLP for the state. And many of cases we lost, you know that.
Not at all maintainable.
A Postmaster General, everything is.
Our judgments are assured.
Take, dismiss. Yes.
34.
34? 34 withdraw. Achha. You want to withdraw? There is a memo?
That was there, my lords, actually. On the last occasion, my lord, sir, review has been filed against the confirming judgment in second appeal on the basis of discovery of new important matter of evidence, my lord. On the last occasion,
Why have you filed the memo then?
my lord, it was filed.
Application rather.
It was filed way back because my lord, it was not getting listed. So my lords,
Out of frustration.
Not sure.
Out of frustration, matters are not listed, so therefore you move an application or withdraw.
Withdraw and let the party to approach.
So first you withdraw this application of withdrawal.
I'm withdrawing, my lords.
Right on. Land counsel for the petitioner seeks to withdraw IA number 314 of 2022. Stands withdrawn. Nah? Next. Yes, on merits you come.
Lordship.
Yes.
On the last occasion, Lordship asked me, because my case, my lords, is that I have filed this review on the basis of discovery of new and important matter of evidence which were not known to the petitioner at the time the matter was pending.
Yes, that is a ground. Yes.
Lordship. So Lordship asked me where you have mentioned in your petition that these things were not in your knowledge at the time of pendency of that suit and appeal. My lords, to that effect, I have filed an IA 1 of 2025 for amendment in para 8 of my review petition. Just to clarify that point, in para 8, your lordship may have a glance to, my lords.
You got wiser by in the last hearing you got wiser, therefore you want amendment.
So I'm learning, my lords, my learned senior at last hearing suggested me this. The para 8, my lords, I've just filed a clarificatory IA.
Who has drafted this application?
Lordship, review petition.
No, this application.
Lordship, IA.
See the amendment what you are seeking.
Lordship?
If something transpires in the court while hearing, if the court express some opinion, how are you incorporating that in the pleading? The court has said that. Where have I said that?
Lordship, which?
This is against the fundamental principle of pleading.
Lordship, which paragraph?
The paragraph 8 you want to replace, just see. Para 4 of your application.
That para 8 of the review reproduced below.
That without describing and discussing the other fact, the entire fulcrum of the litigation lies on the authenticity of the adoption and document produced in providing the factum of adoption, regarding which this honorable court already has stated that the said document that is so and so acknowledged so and so. Where are you getting these observations?
Lordship, I'm not.
Court's observation.
I'm not able to follow, my lords. Which para of which petition, my lord?
The amendment you are seeking.
Lordship, IA.
Yes. IA.
Lordship, which para?
Propose amendment, just see. Propose amendment. Regarding which the honorable court already has stated that the said document, that is the deed of acknowledgement adoption deed so and so, is a valid one. Where from you getting it?
Lordship, it was there in the review petition. Paragraph 8 is there in review petition. I am only.
No, you court's observation, where are you noting?
That without describing.
But due to the discovery of some so and so, and which is diligence not within the knowledge of the petitioner at the time of pendency of the trial, and subsequently appeal before the appellate court, and the petitioner was so and so, only after the delivery of the judgment dated so and so, the same is now.
Lordship, it is a judgment regarding the authenticity of this acknowledgement of adoption.
Who is appealing? See, you are changing the entire ground of the what you call the review petition by saying this. Discovery of the document after the judgment is pronounced. Who is appearing? Notice was issued.
No, my lords.
This application has to be replied by him. I will not allow this application like this. Issue notice on the application IA number
1 of 2000.
IA number 1 of 2025. Only IA, huh?
Gotcha.
IA, yeah. Notice to the opposite party. Only IA I am issuing notice.
Gotcha.
If the IA is allowed, then you may have a case. If the IA is rejected, your review petition is rejected.
Gotcha.
Because you are trying to change the entire scenario after the hearing took place. Last time I said that whenever you got the knowledge, then now you are simply saying that after the pronouncement of the judgment, I got the knowledge.
No, all
That's
the
what you said,
documents-
nothing else.
All the documents that has been annexed in this review petition are dated after this my lord judgment only.
No, no,
I have obtained
no, no,
the
no.
order RTA, my lords.
No, no. RTI is after, but the judgments were in existence. See, documents were in existence. RTI you got letter.
Lordship.
Yes, that's what I'm
I
saying.
got the knowledge after this judgment only.
Then no. That's yes. I'll just issue notice on that IE. Okay. File the process.
Lordship.
Yes.
35.
Nice.
Yes, sir.
35, my lord, the restoration, my lord. Basically.
My lord, restored.
Any delay?
Delay to 30 days.
Huh?
To 30 days. My lord, what happened, my lord?
Will you oppose it? Then I'll issue notice.
Yes.
Issue notice. Delay as well as.
My lordship may restore the matter. Basically, the RFI were transferred to the district judges. So transferred to the district judge court.
Let us see the section 5 application.
Without going to the merits, that may be restored and transferred to the district judge court. All the RFIs are transferred to the district judge.
Where have you said that? In your application?
Yes, my lord, I have said, my lord. But your lord should see the previous order, my lord.
No, in the application of condonation of delay, where have you said all these things?
Main petition I have written.
See, you are seeking condonation of delay. In the application, what the sufficient cause you have shown? Nothing.
Nothing. We have missed the list, my lord. There is a delay.
Then they are entitled to file a reply. Let it issue notice on the condonation in review as well as condonation.
My lord, I have filed an amendment, my lord. My cause title maybe I will add it. Amendment allowed. 3 to 11 I have added.
Amendment allowed. Yes. 36.
Same, 35, 36.
45, outside it is showing as 34. So I did not know. Item 45. Just
We have not reached 45.
Oh, 35.
35.
Anyway, wishing you
With
a very happy new year.
Thank you, sir. Thank you very much.
Same item, my lord, 35, 36.
35, 36. Same issue notice, huh? Both.
So notice and amendment may be allowed.
Amendment allowed. Amendment allowed. IA for condonation of delay notice is issued. Better you file a better affidavit for condonation of delay. You have not said anything.
Yes, my lord.
Counsel for the petitioner seeks leave of this court to file a better affidavit explaining the delay. In the delay application, you haven't said anything.
Yes, ma'am.
Sufficient cause has to be shown.
Yes, ma'am.
You file a better affidavit. Okay. I have issued notice, but still you have to file a better.
Yes, ma'am.
Yes.
Item 37 on behalf of Mr. Maharana, my lords.
Mr.
We have
Maharana
filed
is
an
not well.
application. And he will also file an
Had
application.
many occasions.
I know,
Nothing
but
remains below.
I'll put it 1 week after because he's not well.
But
1 week of
next week. Next week, बहुत दिन पड़े 25 वर्ष गलानी.
नहीं 2024
And coordinate bench has similar circumstances as Quashing.
I'll put it as early as possible. 21st. 21st. Mr. Maharana, Land Counsel for the Vigilance is indisposed. Hence, adjournment is sought on his behalf in the interest of justice adjournment.
Assignment change. Hadin part so that
it has no meaning. Yes.
38.
38, my lords. This matter, the opposite party number 2, my lord, the noting is that the summons are not, AD is not back. The lordship granted interim protection.
Bag. Not sufficient.
Bag. It is bag, not bag.
Not back.
BAG bag. BAC bag.
No, not back. AD 70.
So it is awaiting.
Awaiting.
Service on opposite party number 2 is awaited.
Lordship wants we can take it by special messenger also. Matter can be sorted out here only.
Then you take the notice. Take out.
Lordship permitting, I'll take.
Dasti.
Dasti.
Dasti permission. Permission. Please short date the khatam.
Interim order be extended.
Interim order to continue.
Great.
Interim order.
I'll take Dusty by tomorrow. and deposit
Yes,
it
yes,
first.
you please do that. So
Great.
that we can sort it out. This
Material sorted. It's all about grant of non-grant of clearance certificate and shares deposit.
we can sort it out, it's a very small matter.
It is sorted out here.
Yes, yes.
Great. Sir.
39.
My lord, I am appearing through VC from Dhenkanal, my lord. I file a no instruction memo, my lord. Please accept it kindly. In this miscase, I file no instruction memo.
No instruction.
My lord.
Learned counsel for the petitioner submits that he has no instruction in the matter. Hence,
My name is deleted.
dismiss the info. Okay.
Obliged, my lord.
40.
BJP ne? Notice on the opposite party number 2 is awaited. At least the matter on Sunday. Interim.
42.
41. Acha. 42.
330 years.
43.
43.
Great vigilance. Here, my lord, the petitioner has filed the criminal miscase, my lord, challenging the order taking cognizance passed by the Lord SDJM Kyonjhar, taking cognizance of the offence is punishable under sections 120B, 468, 471 by 34. My lord, it was virtually hard at length on the last sheet.
We have
Ready?
already filed our written notes of submission.
Yes.
regarding- And this person is the advocate by profession, and the transaction they're alleging that done, whatever, my lordship, we have already filed.
I have given the short note of submission. My lord was pleased to take note of the same. And also take a note of the judgment delivered by this honorable court by Honorable Justice Roth, my lord.
Your lordship has directed
My lord may see page 53. That is the answer to the all the questions raised here.
Page 53.
Of the short note, my lord.
Your petition is 47 pages. Short note.
Note, my lord, with citations.
Citations, okay.
Right. Page 53.
Hard copy you see.
Sankar Mishra, he is also a lawyer. It was there because my lord has, after perusal of the judgment, directed my
Can I
lord.
keep it next week? Because I don't want to reserve further judgment. It
Your
is
lordship-
there. Or next week I can feed you.
16, my lord.
16, huh? 16 okay.
15, man. 15 it will wait.
15 or 16, anytime. Oh, okay.
Your lordship.
It was virtually hard. But the lawyer has given some opinion.
I know that too. I understood it.
We have filed.
By judgment of this honorable court in criminal
Justice Ratha's judgment.
Yes.
very clear.
Directly covered.
Yes.
Directly.
Justice Ratha's judgment.
Yes, he has also taken.
Because other judgments are there, this way, that way.
Ballot.
But Justice Ratha's judgment directly covered.
Yes.
Supreme Court judgment is also there. I have
Directly
given.
covered. Yes. 16.
Yes.
Okay.
44.
Interim order to continue.
Interim order to continue.
May please, Your Lordship. My lord, here the in CRLMC.
What happened to Rashmita Patra?
Rashmita Patra that in Supreme Court it is still pending as per my instruction.
It's interim order to continue, awaiting the outcome of
The last
Rashmita
order
Patra.
is there.
So the same thing, same order, last order.
Great.
Mr. Mishra, learned senior counsel appearing for the petitioner, submits that the matter in the Supreme Court is still pending. Hence awaiting the outcome of the judgment of the Honorable Supreme Court in SLP criminal number 2107 of 2022. 23 matter is urgent to serve judge. Interim order pass earlier. Will continue. Please, thank you.
45.
Yes, sir.
In this case, the petitioner is a manufacturer of dental equipments and it had entered into.
Anybody is appearing for opposite party number 2 now? Okay.
Well, and the petitioner had entered into an agreement with the informant who's with the complainant. It is at Annex 3 at page 26.
Yes.
Lordship gets it.
Yes, I got it.
And if your Lordship sees clause 2 definitions, grant of distributorship. Company hereby appoints and designates the distributor as the company's non-exclusive distributor of products in the territory of the term as defined below. So he's a non-exclusive distributor. Now he files a complaint alleging that I have cheated him. I should have only given him the equipments. I have given it to other doctors. That is his entire allegation. On top of that, my lords, there is an arbitration clause. Arbitration is going on in Mumbai. He is participating. He has filed a counterclaim before the arbitrator. Unfortunately, he made a lot of allegations against the arbitrator. The arbitrator recused himself and the Bombay High Court has appointed a fresh arbitrator.
Let us see the allegation complaint.
Yes, your lordships may kindly see the allegations.
Page 22.
Page 21 it starts. Page 22.
Yes.
The main brief facts of the case, the lordship may turn to small Roman 2.
Yes.
There was
There
an
was
agreement between the parties that the claimant may directly contact a customer where the customer is an organization or institution, but violating the basic terms of that agreement, the claimant has a number of times directly approached the customers, doctors in the city of Bhubaneswar and other parts of Odisha and has supplied material to those customers, illegally collecting money from them, violating the provisions of VAT, CST, ET, but mischievously to show that the transaction has been done as per procedure. The accused number 1 has included the cost of the product in the invoice of the complainant claiming the money from him. Now, my lords, your lordship sees his basic challenge is that I have supplied equipments directly to customers and other doctors in the city of Bhubaneswar. My lords, it is a non-exclusive agreement. So I can supply to anyone I choose. You are one of my dealers. That's all. And on top of that, there's an arbitration.
And the next paragraph, the allegation what he has levied is that.
See the VAT, GST, whatever he deducted. No, deducted from the other customers, that is their grievance.
No, my lord. He has used my name. He has collected that money directly from them. He is asking that extra money from me. That is what the allegation is.
So,
my lord,
the 3 numbers.
3 number of Indo Motors model such and such, cordless motors such and such, dental facility to the were sold by the accused company number 1, 3 Bhubaneswar based buyers directly after taking leads from the complainant such and such. The next page, as per the scheme of the accused company number 1, the payment has been collected by the accused company DHR from each buyer in the following dominations. This has been collected, my lord.
Where are you reading?
Page 23.
Page 22, it starts.
Page
small Roman 3. That's what my friend is placing.
1 number of check valued such and such. These are the details.
Just from 3 row.
Clause 3 may.
Clause 3 because that will.
Paragraph 22, my lord.
3 numbers.
Sorry, page 22, clause subclause 3, my lord.
Yes.
My lord. 3 number of such and
so equipment were sold by the accused number 1 to 3 Bhubaneswar based buyer directly after taking lead. From, what is the after taking lead from?
Lead means those customers were mine. They took the lead from me and they sold it directly. That is not this. That is not the issue here, my lord. What he has collected the entire money from them. Now he is next, my lord. Next page, my lord. As per the scheme, the accused company now the payment has been collected by the accused company from each buyer in the following dominations. Such and such.
Yes.
Thus, from each buyer, the accused company number 1 has collected a sum of rupees such and such towards sale of the such the equipment. Latter, either realizing that it is not possible to transfer the products interstate sale without the mandatory proper work of form of VAT and such towards the adjustment of any of the vested involuntary loss of their accused company number 1 has included those in the invoice of the complainant for the total value of such and such amount 2% GST against the way bill provided by the complainant to the bill their materials without prior understanding of the complainant. The details of such and such invoice are, these are the details for, and he has again claimed those money from me, my lord. And my lord, what I pray, my lord may kindly have a glance at the impugned order, what my lord has, what the lower court has said. My lord, it's pending there, my lord. Let a decision be taken, my lord. Why should it be stayed here, my lord? And about the ground, the basic ground on which this honorable court was pleased to pass this interim order was the arbitration is going on. In the meantime, my lord may kindly have a glance. Thereafter, another arbitration was.
Your allegation are twofold. One is by taking the lead from you that these are the customers, he sold it to them. This is one.
That is not primary.
That is no offense.
No
offense is made.
No offense, man.
Second one is he interstate transfer he could not have done, so therefore they used your name. This is the second. And where is the criminality out of it?
But those tax amounts,
has he manipulated document? Has he done anything? You tell me.
Those tax amount he's now.
All these things are commercial transactions.
He's trying to collect it from me again. Once he did.
So for that, sir, you have a valid contract, and there is an arbitration clause. You have they have resorted to the arbitration clause, and you have filed a counterclaim.
No, Madam, may kindly.
This is the same amount.
Madam, may kindly have a glance. The ground.
What is the stage of arbitration?
On arbitration, my lords, the previous arbitrator had recused himself because he made various allegations against the arbitrator. Matter was again moved before the Hon'Ble High Court of Bombay. It is
New
now
arbitrator.
appointment of a fresh arbitrator.
No, my lord. Again, second one has also recused.
Second one, you make allegations.
Why do you create problem for arbitrator?
Go on making allegations against the arbitrators for the recuse.
Madam, though these facts are not related to the case, there are lot many things which are behind this matter. This company.
But I have today I have to only see the allegations.
That allegation is he has already taken. He has done.
Better you pursue a remedy in the arbitration and get the money back. That's the only thing.
No,
this is the non-exclusive dealership. And you had a dealership, no problem. But since it is a non-exclusive dealership, they can sell their product. How does it make difference to you?
They are not depositing the tax amount, and in addition to that, they're troubling me, asking him for that tax amount.
For that, remedies are different.
For
that, remedies are different. Not the complaint.
Allow me 1 week. I'll file certain documents.
To section 256, capital B.
Next
income tax. Go there.
I will find a short counter thereafter. May
go there.
Sir, another thing, just for your lordship's understanding of the case, my lords, he has also now filed a civil suit for a declaration that the agreement is void.
No, how will he is relying upon that same agreement and file a counterclaim. The moment he says that, then counterclaim goes.
Then the criminal case he is filing. My lords, I have just because I appointed him as my distributor. Well, lords,
what is the claim basically?
2,50,000 he is claiming from me.
Totally 2 lakhs.
I am claiming.
I need to pay and finish. We are spending a lot of money here.
But I am to get about 15 to 20 lakhs from them. All the invoices are painted. 2.5 lakhs is not the issue, my lords. He cannot blackmail me in this manner. That is the problem.
I'll file the entire thing in a
Land counsel for the opposite party seeks an adjournment to file the counter to the present petition. Leaves the matters on so entry model to continue after 3-4 weeks there. Please.
Malad, Nitesh Kumar Jay Shah's case, Malad, they say whether there's an arbitration.
Yes, I know.
Your lordship is aware.
So I'll just say the proceeding in the arbitration something may happen. Yes.
Entry order may cut.
Entry order cut.
Oblige.
Better, sir, better use setting the issue. You will, in the end of the day, what will happen, you know? You spend more money in the litigation than what you are claiming.
But in fact, the facts are totally different than what is presented here.
But you can't improve your complaint by adding something. Whatever you have said, no case is made out. What to do? Yes.
47, my lord. Here, this is covered by a lordship's judgment in Sri Metallic's case, my lords. Here, income tax, my lords, tax deducted at source, my lords, there was a delay in depositing these amounts. He was not aware that if he collects it, let's say
now the regime has changed after a circular.
My lords, exactly. He was not aware of this.
I'll give you that liberty. Go and file it.
We have already filed it along with interest. They have accepted it.
No. The compounding, there is no compounding provision, clear-cut compounding provision. Because of this kind of cases,
yes,
they have come out with a circular. That is 17th October, if I'm not 17th October 2024.
17th October
2024. There, just see, they have very clearly stated it. Since these kind of cases can be compounded. If there is a provision of compounding, 482 doesn't lie. So therefore, in that line, I'm disposing of.
If you're watching, no, this is an older circular. I'm not aware of the new circular. Otherwise, let it come up next week. Next week, we'll get that circular.
No, I'll dispose it up. I have the circular.
In terms of that.
And I'll simply say that the compounding provision is there. I'll reproduce those compounding provision. On that basis, you move the application and it will be done.
Deeply obliged.
Okay. Reserve. There is a number. Okay. Because earlier there was no clarity.
Clarity regarding compounding.
And now the very specifically 276BB and 276, everything is included along with the provision.
Yes.
In the presence of that, only thing is you have to pay the compounding fees of 25,000. There. So therefore you pay it and finish it up. I'll record that.
Certainly. Okay. Deeply obliged.
They are ready to compound.
Yes. And your lordships will also record that. They are ready to compound.
Appearance.
Obliged.
Yes. I'll pass the order today itself.
48, may I please, my lords. My lords, in this case, I have filed this application for quashing of the entire criminal proceeding. My lord, on the ground that no case is made out at the prima facie, my lord. There was a EPC agreement, my lord, before placing it on merits, my lord. The present petitioner is just the manager of Watco, my lord. My lord, may I draw into the FIR contention, my lord. Running page number 20.
20.
Yes, my lord.
Yes.
My lord, the of Watco is the informant for initiation of this proceeding, my lord.
Yes.
Where he says that because of my negligence, there was death of the sanitary workers, my lord. My lord, now may I draw my lord's attention to the EPC agreement, my lord. Engineering, procurement and construction agreement, my lord. Which starts, my lord, from Annexure 4 series, my lord.
Yes.
And my lord, first may I draw my lord's attention to running page number 69.
69, huh?
69.
Yes.
3.1.8, my lord. There was a EPC agreement between the contractor and the Watco, my lord. And my lord, it says the contractor shall undertake all necessary superintendence to plan, arrange, direct, manage, inspect, test the works, my lord. So it is on the contractor. And subsequently, my lord, to the extent of precautionary measures also, it was to be taken by the contractor only, my lord. Just with a ulterior motive, the MD has filed this, has launched the complaint and FIR was registered and cognizance has been taken. So far as negligence offense is concerned, my lord, 304A. May I read the same, my lord?
Yes.
It says, whoever causes death of a person by doing any rash or negligent act not amounting to culpable homicide, my lord. So necessary things is rash or negligent act has to be done by the accused, my lord. But in this case, my lord,
there is no act.
There is no act. That is my case.
That's what you are saying.
Yes, my lord.
Yes, what is?
The private
He is not. There is no act is attributed to him.
Because he is responsible, my lord.
Responsible is something different.
Yes,
You could have brought some other provision. But
Yes.
304 A, how will you bring?
And 304 A versus. Apart from that,
He had to participate in the attack.
private party has appeared and filed a show cause.
My lord, there also your lordship may just peruse that show cause.
Who is appearing?
My lord, on several dates, they have not, although they have filed the show cause, but they are not appearing. My lord, that doesn't disclose anything with regard to the commission of offense.
Let them come. There is an interim order. Right?
There is an interim order, but my lord, since long this case is pending.
But see, file the show cause, then he
As
has
a
to
last
heard.
chance, your lordship
He
may
has to
just
be heard.
reflect that, and this matter can be disposed of.
Although the opposite party number 2 has filed replies to show cause notice, show cause reply, however, non-appears for him. In the interest of procedure to so and so, the interim order pass on 16/8/2023 shall continue.
My lord, may fix a short date.
He will give it. Yes.
And my lord, as a last chance, because my lord, on several dates.
But you have a last chance.
I'm grateful, my lord.
Next. 1 minute. Yes.
49.
Well, this is that case where a divorced lady who has not remarried, is she entitled to maintenance or not? The section clearly states.
The same.
Proceeding is under challenge.
The divorce proceeding, your lordship, I had mentioned it on the last occasion. My lords, the
What happened to that Mata case?
it's pending before this honorable court. And my lords, there we do not challenge the proceedings.
That's right, I understand it.
And only permanent alimony is to be worked out. Now, in the meantime,
that is what the problem is. What he says is if the divorce proceeding divorce is granted with permanent alimony of 17 lakhs or something.
Yes.
And you both of you are fighting on the alimony part. But insofar as the divorce part is concerned, both of you agreed for divorce.
Yes.
What he says that once divorce is granted and you have agreed to concede to that, then you are not entitled to maintenance. That's what his case is.
That is exactly against the statute itself. The statute says 125. Explanation B. Wife includes a woman who has been divorced by or has obtained a divorce from a husband and has not remarried. Till date, she has not remarried. That is not his case also. No. And my lords, 127, he has to alter. If at all he feels,
then 127.
127 he has to alter.
Now the situation changes.
Here it is
What you are trying to say is he can bring a fresh 125 proceeding. The earlier goes.
That was the final divorce of a final alimony was fixed. My humble submission before.
No, fine maintenance has to be.
Yes. So that portion is over. The son and the daughter and the wife are granted maintenance. Son has become major. Daughter has also become major in the meantime. Of course, that is not to be adjudicated here. The wife has the status of the wife. Before a fixing of a permanent alimony or fixing a permanent lump sum money for her, she was getting maintenance. And up to that maintenance, still decree of divorce I have already paid. That is not in dispute. But after the date of decree of divorce, I have not paid to the wife. That is also a fact. I don't dispute. But if she has a claim, she cannot get the same maintenance which she was getting prior to the decree of divorce.
It needs to be adjudicated at first.
After change circumstances. Because now her status has become a divorced wife. And my status when I was serviced, now I have taken VRS and my money here has not been fixed. My pension has
Then I give a direction to trial court to decide a fresh.
My lord, what he is saying is totally against the statute. The statute, that is why the legislature was conscious that such a situation may arise. And that is
no, he concedes to that. What he says that
and even
you can maintain a 125(2) proceeding
my lord,
on the fresh ground that in the changing circumstances that you have got.
No, my lords. My lords, 125, that is exactly why 125 My lords.
You want to continue that proceeding.
That
And he says that you file a fresh proceeding.
No,
That's the only
my
difference.
lords, proceed.
That's the only difference.
Because that proceeding is final till the end, which has been upheld by the Supreme Court.
Yes.
Now 125, no, 125, your lordships may kindly.
That is not final. See, it was not finally decided.
It is not final.
That's the problem.
No, another thing, my lords.
What
is my statement?
What I'll do is, see, don't go to technicality. What I'll do is, I will direct the trial court to decide the application, 125 application afresh in the changing circumstances. As simple as that.
Then my lords, it will be totally against.
You can't have both. You take the alimony of 17 lakhs.
No, I'm not.
And you say that, give me
Your lordships may kindly see 120.
You are seeking, in the same time, you are seeking enhancement in the alimony.
Yes.
So this is a changing circumstance. There are two changing circumstances. One is, you have been divorced and you have considered to that type of position.
Yes.
This is one changing circumstances. Second changing circumstances, wrong, right, whatever. There is a award of 17 lakhs as a permanent alimony. You are not satisfied.
I have accepted it also.
You are not accepted it.
He might have.
See, then you would be getting. No. You would be getting.
It's valid.
Permanent alimony. Either 17 or more than that.
Yes.
Either 17 or more than that. Okay. So this is also a changing circumstances. In these two changing circumstances, the 125 proceeding has to be decided afresh. That's all.
Your lordships may kindly see 127.
Yes.
If your lordship wants it on any other date, because I think your lordships will be rising up for.
I am finding out a shortcut.
My lords, I'm reading 127.
Yes.
What your lordship is saying, my lords, that is exactly it is covered by 127.
127 is the consequential to 125.
Yes, my lords. I'm just reading
He
it.
says that the 125 goes.
No, I'm just reading it.
You have to bring a fresh 125.
No, that is against
the problem.
statute.
Yes.
Your lordships may kindly see 127.
127. Okay.
Yes. Alteration in allowances. Ultimately, he's saying that your lordships may read 127.
Yes. 127, right?
127(1). On proof of a change in the circumstances of any person receiving under section 125.
That's what precisely
the entire thing I'm placing. Yes. Or of any person receiving under section 125 a monthly allowance for the maintenance or interim maintenance, or ordered under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, child, mother, or father or mother, as the case may be, the magistrate may make such alteration as he thinks fit in the allowance.
That's what I'm precisely saying. Either you move a 125.
Then
that is in the nature of 127 only. I'll simply say, move an application under 127. That will be considered. That's all.
My lords, he has come up against an execution. Right, my lords? Now, he has to move the magistrate for a change in the quantum of maintenance, if at all. Saying that he has to do it, not me, my lords. He has to do it under 127, telling the magistrate, sir, I have deposited 17 lakhs and she has agreed to table, whatever. He says, and the magistrate changes it. Then, my lord, certainly, whatever the subject to challenges before this honorable court, Supreme Court, wherever, then that matter will be changed. But in an execution proceeding, how can he challenge the interim maintenance which has been granted under 125? That is exactly what he has challenged.
I will direct the trial court to treat that application, pending application, as a 127 application and decide it.
Yes.
Simple.
Let him file an application under 127.
I will direct the trial court to deal with that application as a 127.
Yes. So this order has to go. Let him this order has to go then. No. His application for no. I understand. I get your point. No. I'm not having the egg or the chicken. I would rather have a goat. But butter is much more preferable than boil and chicken.
Mata proceeding, exactly. He's asking that.
If your lordship, if your lordship directs,
I'll only suggest one thing. Don't go into technicality. Try and find out a solution. These are matrimonial disputes.
Exactly.
You are interested in your maintenance. He will give or not. The court will decide. I am not going to decide the maintenance.
If your lordship
In the form of 127 or on the form of 125, it has to be decided.
If your lordship says that he can move an application under 127 for variation of this order, I have absolutely no qualms because he has a right to do it. But as it is, this order stands today. So let him move an application.
But he has filed an application in execution that after the date of decree of divorce, you pay the maintenance. I raise the point that such maintenance is not payable to him. Such maintenance is not payable. Let him file.
No, what he says that 127 has to be filed by you, not by him.
When I raise that point, that she is not able to get maintenance in the previous proceeding because there is a change circumstance now. She has become a divorced wife. And yes, there is no dispute that a divorced wife is entitled to maintenance. What prevents them to file a fresh 125?
No,
why they will not?
Same question he is asking. What prevents you to file 127? That's the problem.
The matter of judgment, if your lordship sees the interim judgment with just challenge.
Let the interim order continue. We'll wait till the matter is decided. Then we'll see. Matter is decided. What to do?
Interim maintenance, if she doesn't get, she will be.
That's what I am trying to find out a way out.
No, that is not for maintenance. They are not moving there. They are after them because they will get.
You have moved an application there.
Have we moved an application
Yes.
in Mata? This amount is
That's why the matter of five was fought for.
to Mata, sir.
Because
My lords, this amount has been fixed prior to the Mata case.
No.
No, have you?
Yes.
Have you moved an application in the Mata proceeding?
Sir, we
For
only made
maintenance?
an application that he should give the area maintenance.
No.
That is what the court ordered. That is an order. This guy.
I'll hear it.
No.
Put it after 2 weeks.
Yes.
While we interim
After 2 weeks, I'll.
Interim occupants.
I don't 50
And any adjournment you can.
Item C.
May I please, lordship?
Yes.
In this case, I am challenging the order of cognizance, lordship, under Annex 2. Initially, the complainant filed a complaint case before the current magistrate. But prior the filed complaint case, the complainant nothing any report before the police station nor the SP. And the current court below without any verification of the matter to cognizance against the petitioners.
Hey, for the purpose of 156.3, you need to give complaint.
Yes.
If it is a 200 petition complaint, why should
But prior that, not any report given the police station or any.
if it is a 200 complaint, it is not required.
Yes. And here in this case,
It's not a 156.3.
yes, lordship. And
200
here-
complaint.
Here in this case, the petitioner and the informant, both are the neighbors. During some misunderstanding between them, that the case has been arising. That is the case, lordship.
Yes. But why it should be quashed? Why it should be quashed? Tell me. Its case is made out. It's made out. Why should it be quashed?
Notice may be issued.
Why? You have to make out a case. Notice is not routinely issued.
Yes, sir.
You tell me why. What is your case? You file the complaint
Complaint case.
and the cognizance order. You make out a case. Why? How the cognizance order is wrong? What are the grounds of challenge?
Order of cognizance, lordship.
Yes. What are the grounds?
Ground is that both are the neighbors, lordship.
Both of the neighbors. Therefore,
Yes, sir.
you started fighting with them.
Some,
Therefore, they filed the complaint. That is not a ground.
yes, sir.
Yes. You tell me what are the grounds. Just see your petition. Nothing is written.
No, lordship, I can keep it to any other date, lordship.
Any other date, what will you do?
Any statement is not there which may lordship.
Now you withdraw and file at least file proper documents, and what are the grounds you write something. This is no way of doing it right now. Then counsel for the petitioner seeks to withdraw the present petition to file a better one with better particulars and documents, supporting documents. The liberty the petition is disposed of. Yes, next. File a better one.
Lordship, written in the certified copy, Lordship.
Certified copy written. File a better one.
Yes, sir.
And making out a case, then only the court will interfere. Yes.
So 9 by lot. And so 9 on the basis of compromise between the parties, I have filed this application. Passing of the proceeding manual.
Yes.
All the accused persons are present, including.
Yes. Charge sheet has been filed?
Charge sheet has been filed.
Where is the charge sheet?
Charge sheet next page 7, page 17.
I'm referring to the informal money.
Page 17.
17, okay.
341, 223, 297, 440.
Oh, 34, 506. Yes. There is nothing. Yes. Who all are the.
I am for the informal money.
Are you opposing?
No.
They have also filed application.
I am also filing.
Okay. Okay. Who are they? Let us see. All of them are there. 41, 323, 294, 448, 506, and 34 IPC. What is the stage of the trial?
2007, nothing has only the cognizance has been taken on 2009.
Although by the order dated 19/10/2009, cognizance of offences as mentioned above had been taken by the court of JMFC Burville. However, the trial has not yet been commenced. When the matter stood thus, the parties have settled the dispute and filed the present petition. The petitioners and the petitioners have placed on record a compromise affidavit dated 21 August 2024. Entry India stating as under Annexure 3, Annexure 3, Para 2 and 3, 2, 3. Para 2 and 3. On the basis of the said compromise settlement, the petitioners have approached the present compromise affidavit shown by the opposite party on so and so. Para 3 and 4. Okay, 2 and 3. The petitioners have all the petitioners have separately filed affidavit before this court. Affidavit dated 7/1/2025 before this court. Conjointly stating in unison that they have settled the dispute with the opposite party number 2, the informant, and due to misunderstanding and sudden provocation, the incident had taken place, and they have regretted for the commission of the offence. The opposite party number 2 has also filed a separate affidavit dated 7/1/2025 before this court, and reiterating his stand, and has also stated that due to sudden provocation, the incident had happened, and he had lost the FIR. Now, due to the intervention of the well-wishers and local gentries, the matter has been amicably settled, and he doesn't want to proceed against the petitioners anymore. All the petitioners are present in person, being represented by their counsel and identified by him, and they have also filed the self-attested copies of their Aadhaar card. The opposite party number 2, the informant, is also present in the court, and represented by his counsel, identified by him, and he has also filed the self-attested copies of the other. From the query from the court, the opposite party number 2 submits that he in the year 2009 he had filed the FIR 2007. No? In 2007, the incident states that the incident had taken place on 5/5/2007, and due to sudden provocation, he had filed he has lost the FIR. And the matter is pending since then. Although the although the charge sheet was filed in 2009, the trial has not yet been commenced. In the meantime, he has settled the dispute with the petitioners and joined the petitioners, making the prayer for quashing the entire criminal prosecution. Mr. Biswal appears for the state and submits that since the allegations are minor in nature and the case is pending since last many years, parties have settled the dispute, therefore there is no legal impediment in cost of the FIR. They are to the aforementioned and glancing and all cost. Yes.
Item 11.
Item number 11, your lordship. Lordship, ma'am, challenge you to order dated 28/8/2024. My 205 petition has been rejected, your lordship.
Yes.
And no allegation has against me, your lordship. And one of the accused had already filed his application, and his application has been stayed, your lordship.
Yes. Complaints.
The main accused is
405, 406. Yes. Why can't you appear in the court?
And your lordship, kindly see page number 46, your lordship. The magistrate has taken the cognizance against one, the Tara Prasad Paul and the MD of the company. They have not taken any against me, your lordship. They have not taken any against me. And your lordship, kindly see the once is a petition also. There is no allegation against me.
Who are you? If no cognizance is taken against you,
but they have issued summon to me, your lordship.
Have you challenged that summon order?
No, your lordship. I am only challenged the 205 petition.
Why you challenge the summoning order? Why are you challenging 205?
Well, lordship, I am pointing to page 57.
Huh?
6.
They had made party, but then the court has neither taken any cognizance against me.
Yes, see page 46. yes, 46. Cognizance order.
Managing
I am
director.
prima facie satisfied that the case under so and so is made out. Hence, cognizance of offense so and so are taken against the accused persons, namely one, Tara Paul, and two, the managing director of. So, are you the managing director?
No, your lordship. I am not the managing director. I am the chairman of the company.
But cognizance is not taken against chairman.
But page 57. I have filed a petition to amend the complaint with the including
strange case where a complaint petition, a criminal complaint was amended.
How can you do that?
And he was added as a party.
A cognizance is taken against him. Answer it. Then
the managing director and Paul, Mr. Paul.
Paul. Tara Prasad Paul.
Paul is here.
Individuals.
Don't take cognizance against him now. If the cognizance is not taken, how will you amend this? No. Then why, Bishop Paul, why are you not challenging the?
I have already applied for certificate, but that is what I.
You are after 205. Why are you interested to appear to?
No,
you challenge that summoning order.
I have been summoned. I filed the application for.
You challenge that summoning.
Yes. I have applied for certified copy of the entire order sheet. Because how a criminal complaint can be amended? It is totally alien to me, man.
I issue notice. And what do you say? I issue notice, then stay. Then the entire thing will go.
Yes, ma'am. That will be better.
Qua him, it has to be stayed. If this is the case. Petitioner reject.
Managing director of that company instead of managing director, chairman should.
Where is the complaint? Where is the complaint?
The person may change, but the designation for managing director, how can the managing director?
No. Come to page 29. The complaint is against managing director.
Yes. Thereafter, they added the chairman as a party.
You can't
He
do
is the
that.
Chairman of the group.
See the memo of see the complaint. Complaint is Tara Prasad Paul and managing director of Simplex Infrastructure. A cognizance is taken against them. Now you want to bring chairman also. Right up. Petitioner is agreed by the order dated 28/8/2024, passed by Learned James JMFC City bracket Kotak in ICC case number 239/2019, whereby his application under section 205 CRPC has been rejected. Mr. Pal, Learned Counsel for the petitioner, submits taking me to the copy of the complaint placed on record as Annexure 2, submits that the complaint was filed against one Tara Prasad Paul and managing director of Simplex Infrastructure Limited. The court below had taken cognizance of offences punishable under section taken cognizance by the order dated 20/2/2020 for alleged for offences punishable under section 406, 470, 420, 423, 34 IPC against the aforementioned two accused persons. The petitioner is neither made accused in the complaint nor cognizance has been taken against him. However, summons were issued to him in persons to which he appeared before the court and moved the application under section 205 CRPC, which has been rejected by the impugn order. Issue notice to the opposite party. Opposite party number 2, Mr. Vishwal accept notice for the state. In the meantime, the proceeding qua the present petitioner is state. For proceeding qua present petitioner in the ICC case number 239 of 2019 pending before the court of JMFC City, Cuttack is state. Yes.
13.
13.
30.
One week appearance. 1 week appearance.
Adjourn on request. Yes.
51.
Mediation report has come, that is flat fee.
Successful.
Yes, successful. Mediation became successful.
Yes. Who is appearing for the opposition?
Other said has appeared, his file vocal app now.
I would have allowed it. What are the offences?
Very minor offenses. 341, 294, 320.
Who is appearing? Just see. I call him. I'll allow it.
You were there. He was there.
Let us wait. Possible. Good possible. He may come. He may come. Shall I put it tomorrow?
Tomorrow.
Tomorrow. Put it tomorrow and call him. Yes.
52.
I'll incorporate that mediation report and dispose it up.
Yeah.
Yes.
52.
My lord, I have appeared for the opposite party and today I file my objection.
52.
My lord.
Have you got it?
No.
Opposite party submits that he has entered appearance for opposite party and has filed the response to the present petition. However, the copy of the same is not supplied to the counsel for the petitioner. He may do so within 2 days. Release the matter. Yes.
53.
One person. Amit Prasad was election one person.
What is this matter? Illicit on request Please, interim order continue.
Your Lordship, I'm appearing for the informant. Your Lordship may not adjourn the matter because whenever the matter comes, there is an adjournment on the side of the petitioner, Your Lordship.
Pass over. Yes.
54.
Maybe. One is the employee, one and two are the private person, whereas he is the employee of the legal department. Now, organization has been taken and we turn to page 24. He of RP and UPR on which the cognizance has been taken. The
Yes.
entire application has been made in the PR, because we can put in the annex of 1.
Yes.
Admitted in the plain petition of 1 and 2 are the
Arun Agarwal, Deepti Agarwal,
they are the they have a common traders, and that particular traders by through a auction has managed to be taken participated in a bid and being successful to lift up the raised concrete cement sleepers. That is 12,416 numbers, which was not allowed in their favor, and they are supposed to lift that particular sleepers from the particular boundary of the area. And then this particular sleepers contains the cement, concrete, and some sort of rod manner, which is required to be demolished by the manual level, and it has to be lifted manner. And because of the fact that it was lifted, part of the same was lifted, and the rest because of the rainy season, and both these particular always kept on the side of the railway track, so that it was not possible on the part of the petitioner to lift up 1 and 2 to lift up the particular sleepers right at the moment. So it was stopped at this same place, and thereafter after some time when it was proposed to be lifted up, and by utilizing their manual labor for 10-12 days, some iron was collected and it was proposed to lift up. Now this position has come up because of the fact that in the meantime another person becomes the bidder, and he has I am able to get the particular two-way auction. He has become a successful, and because of some liability, he has made a complaint, and now this is the result. My humble submission, admittedly, I was a person who is legally entitled to lift up that particular sleepers from the particular place.
Yes.
And as the regular process, whenever we transport and by demolishing the breaking up of that particular place complete cement matter, this is iron. It always requires a permission from the authority, and all the times I have taken the permission. Now, but the remaining part matter, I tried to lift up matter. Now figures come up, and now they have also made allegation against piece number 3, who is an employee of the particular railway department, that he has assisted matter. So my humble submission, when the teachers come up in second, piece number 3 has been added, a sanction from the authority also not matter. That has not been taken matter, that is the admittedly part matter. And admittedly, in particular case, I am legally entitled for the same, and I am entitled to lift the particular thing. But on the contrary,
Show me that you are entitled.
Correct. There, madam, see, that is they have admitted on to page 11, last part.
Yes.
Highline from the bottom. Inquiry has been conducted from such and such, senior engineer such and such, and he stated that these materials were being delivered to the purchaser, Kamadenu, the petition 1 and 2, Raipur. But on demand, he could not produce this document, even when he was going to be pending in the SRO and not informed to RPF on account of and process on a constant.
Show me the document. Now show me the document.
I have to show you. Please, I admitted that.
What admitted? You couldn't show the document and.
It was then gone to the.
See the facts which you have narrated. So complicated facts. It has to be, yes. Yes.
Kamadenu Traders, Raipur has purchased 12,460 pieces of PSC slippers, but he had not left the values. It is their case that I have taken up, it is my case that I have not taken up. So
no, it's not. Don't make it so simple. You have to substantiate your case.
Yes.
If you are authorized to take it, show me authorization.
I will file.
Otherwise, you don't have a case. Cognizance is rightly taken.
No, and here they themselves are admitted to the sector that I have made successful the process of reading her. I have allowed.
You file the necessary, Mr. Chand, Land Counsel for the petition, seeks time to place on record additional document to substantiate the case, release the matter after. Yes,
Archive is
next.
fixing in debt, my lord.
Huh?
My lord is fixing in debt.
Which matter? Your railway. He wants to file some certain document. Let us file. Yes. Yes.
55.
Your Lordship, item 53, my learned senior is here, Your Lordship. One pass over here. So
Wait, pass over after, immediately after. There are few number of matters I'll just check. Yes.
The petitioner is a minor and a student. He was appeared the CBSE course, and for a false case by the complainant, he has been dragged to the case, and he was arrested and produced before the Juvenile Justice Board, and he was granted the bail under Annex 2, page 15, under section 307, 341, 294, 323, 325.
Why should it be quashed? Just tell me.
Because my lord, I was under treatment on that the same day and the time of occurrence, Annex 419. But they have not taken into consideration, and only somebody said my name, and it has been registered the case and arrested me.
A plea of alibi.
My lord.
Plea of alibi. Is a disputed question of fact. It has to be decided in the trial.
And the last occasion, Lord Sir, the charge sheet. I have filed the charge sheet and
Yes.
the Annex A. And page 16.
Come to the charge sheet.
Yes, page 16.
Yes.
Page 16, bottom 6 lines.
Yes.
As prima facie evidence is well made out against 3 accused persons, my lord. 1, Pradeep Digal, age 19, father of so-and-so, unit so-and-so, district Khoda. 2, Pradeep.
Yes,
Digal,
so-and-so.
so-and-so.
Akash Dagar. What is your name?
Also 3 is Akash Bhadai, 20, Ganesh Harijana Sai, Chandi Vasta, PS.
Yes, forget the names. And one CCL.
Yes. CCL.
That is Namit Singh.
No, Manmeet Singh.
Yes.
Satyanagar near Kalipana, so and so. As they have arrested me, only they have reflected my name in this charge sheet. Only specifically they said 3, the prima facie made out except 3 accused persons.
You read the sentence, sir. Pura sentence padonto apno. 3 accused persons, so and so, so and so, so and so, and 4th one is you, CCL. You are the CCL. That can't be a ground for.
But at the time of occurrence, I was in medical, my lord.
See, that is a.
Come to the statement of the complainant at page 18. Nowhere it is whispered that the Manmeet Singh was asserting or saying anything or whatever it may be. Nothing has been said, my lord. More name or Asminanjan at page 18, my lord. The statement of the complainant. More name or Asminanjan Sahu, Pita Purnachandra Sahu, plot number so and so, Gita Bhavana, Immediate, Kharavanagar, Bhubaneswar, Ruhe, Aji, 23 Pakare, Hajar Hoi, Boyan Deochi, Agar Madhusudan, Ancholare Ruhe, into Ebe unit Nore Rochi, Mu Prai, Sama, Sandhya Samare, Madhusudan Nagar, school Pakare, Bosa Bosi Koru, Karana Setare, more Sangamane Roti, Oditiva, Mote Chota Luha, Rod Ani, Mote. ଜୀବନରେ ମାରି ଦେବା ପାଇଁ କହି ମୋ ମୁଣ୍ଡକୁ ଆକ୍ରମଣ କଲେ ଓ ମୁଁ ପଛକୁ ଘୁଞ୍ଚି ଆସିବାରୁ ରଡଟି ମୋ ଥୋଡିରେ ବାଜିଲା ଯାହା ଫଳରେ ମୋ ଥୋଡି ଓ ଦାନ୍ତ ଭାଙ୍ଗିଗଲା ଓ ବହୁତ ଜୋରରେ ରକ୍ତ ବହୁଥାଏ ମୋ ମୁଣ୍ଡରେ ଆଘାତ ହୋଇଥିଲେ ମୁଁ ମରି ଯାଇଥାନ୍ତି ସେମାନେ ମୋ ସାଙ୍ଗ ଅମିତ ଓଝାକୁ ମଧ୍ୟ ଜୀବନରେ ମାରି ଦେବା ପାଇଁ କହି ତା ମୁଣ୍ଡକୁ ମଧ୍ୟ ଆଘାତ ଯାହା ଫଳରେ ତା ମୁଣ୍ଡ ମଧ୍ୟ କ୍ଷତ ହୋଇଛି
Show me the statement of Amit Oza.
Amit the next.
The victim.
Here the statement.
Show me injured witness. Yes, Amit Oza.
Manit Singh name has been taken by this.
Amit Oza. Okay.
No. Only complainant only.
I know, I understand.
Then next.
ରାସ୍ତାରେ ରଡ୍ ପଡିଥିଲା କିଏ ନେଲା କାହାକୁ ପଡିଲା ସେ କଥା ମଧ୍ୟ କାହା କଥା
Injured witness is taking your name. Why are you unnecessary saying that?
Then next
my name.
That is 307. That is the only thing happens. Injured, if injured witness says that he has beaten me,
No.
and go and trial and establish that.
My lord, come to the victim, Amit Oza.
Amit Oza
At page 19. At page 19. More nama Amit
Read
Oza.
it.
Ita Bhimasen Oza. Plot number so and so, unit so and so. Kharabalo Nagar Bhubaneswar ruhe. Aji ta 23 ଏତେରିକ ଆପଣଙ୍କ ପାଖରେ ହାଜର ହୋଇ ଏହି ବୟାନ ଦେଉଅଛି ଯେ ଆଜି ସନ୍ଧ୍ୟା ସମୟରେ ମୁଁ ମୋ ସାଙ୍ଗ ରଶ୍ମି ସହିତ ବିବେକାନନ୍ଦ ସ୍କୁଲ ପଡ଼ିଆରେ ବସିଥିଲୁ। ଆମଠାରୁ କିଛି ଦୂରରେ ଅନ୍ୟ କେତେ ଜଣ ପିଲା ମଧ୍ୟ ବସିଥିଲେ। ଏହି ସମୟରେ 4 ଜଣ ପିଲା ସ୍କୁଲ ରାସ୍ତା ଦେଇ ବାଇକରେ ବାରମ୍ବାର ଯିବା ଆସିବା କରୁଥିଲେ। ସେମାନେ ମଧୁସୂଦନ ଅଞ୍ଚଳର ହୋଇ ନଥିବାରୁ ମୁଁ ମୋ ସାଙ୍ଗ ରଶ୍ମି ମିଶି ଆମେ ତାଙ୍କ ପାଖକୁ ଗଲୁ ଓ ତାଙ୍କୁ ପଚାରିଲୁ, ଭାଇମାନେ ଏଠି କାହିଁକି ବାରମ୍ବାର ବୁଲୁଛ, କଣ କାମ ଅଛି? ତାହାପରେ ସେମାନେ ଆମକୁ ଖରାପ ଭାଷାରେ ସୋଦାସୋଦି କଲେ ଓ କହିଲେ, ଆମେ ଏଠି ବୁଲିଲେ ତୁମର କଣ ଗଲା? ଗୋଟେ ଓ ସାଙ୍ଗକୁ ପିଟା ମରା କଲେ।
Last line, you read the last line. Why are you reading so much?
My lord, no.
ତାପରେ ଆମେ ଦୁଇ ଜଣ କ୍ୟାପିଟାଲ ହସ୍ପିଟାଲ କୁ ଯାଇ ଟ୍ରିଟମେଣ୍ଟ କଲୁ। ମୁଁ ସେମାନଙ୍କ ନାମ ଜାଣିଛି, ଯାହାଙ୍କ ନାମ ଦିଲ୍ଲୀପ ଦିଗଲ, ଶୁଭମ ନାୟକ, ଆକାଶ ଗଡେଇ and Manpreet Singh.
Then next page also.
ଖାଲି ନା ଜାଣିଛନ୍ତି।
Equally, everybody has the same role.
Stereotype, my lord.
That's 161 statements are all like that only. What to do?
My lord, the innocent student is a suffering and parents is always moving to the police station to court, my lord. And he is not in a mental peace to study.
Petitioner is seeking quashing for the FIR. The petitioner is one of the accused in the FIR number so and so. Allegation against the petitioner is so and so. Petitioner seeks quashing for the entire FIR on the primarily on 2 grounds, namely petitioner is a child in conflict of law, being a minor, and he has already been admitted to bail. Secondly, he continued by relying upon the medical document filed as an Excel 4 to this petition. Submit that at the date of occurrence, he was in the hospital. He has relied upon some medical prescription. The plea of alibi being a question of fact need to be established in the trial. It needs to be established in trial. Merely because I have perused the statement of the witnesses, injured witnesses, namely the informant and what is his name? Amit Oza, and other statement of other witnesses. All of them has taken the name of the present petitioner along with the other assailants. And therefore, I'm not inclined to quash the FIR at this stage. Hence, the petition is dismissed. However, liberty is granted to the petitioner to raise all the points before the court below at the time of framing of charges. Yes.
My order dated 14/8/24. The opportunity, sufficient opportunity has given to the complainant, but he has does not appear and not speak anything.
Charge is in frame.
No, he has been appeared.
Charge has not yet been framed. Charge has been framed or not? That liberty I have given. You argue that. Yes. Next.
56.
At the request of Mr. Divedi, urgent.
The IIM filed for the vacation of stay, the 125 proceeding, the stay.
Then you have taken stay. How can you? Why?
The last time also he has taken time. The 125 proceeding, my lord.
13. See, you have taken a stay in a maintenance proceeding. He is asking for vacation.
She has not disclosed in her statement of evidence because 2 facts I have filed a case for 340.
That is the domain.
16 by way of last
that is
on the request of
that is the domain of the trial court.
The request of Mr. Divedi, the matter is adjourned to so and so, and which is being opposed by the counsel for the opposite party. Leaves the matter on 16. It's made clear that no further adjournment shall be granted. Interim or to continue.
Sir,
Made please, Lord. The petitioner is challenging Annexure 6, which is the order of cognizance. Order of cognizance has been taken under section 498A majorly and section 3 of the SCST Act. Subject to Lordship's acceptance, my Lord, two submissions that I would like to make before this honorable court is that, Lordship, allegation is under 498A. 498A is not made out because they are relying upon a deed of declaration of marriage, as provided a judgment of this honorable court that a deed of declaration of marriage passed by the notary is not a valid piece of marriage. It's not a valid marriage.
Yes.
Therefore, without a valid marriage, an allegation under section 498A cannot be brought. Number one. Number two, my lord, with respect to the 3 SCST Act, your lordship may kindly have a glance at Annexure 4 at page number 32.
Yes.
Is the bail order. Your lordship may kindly peruse the 4th paragraph. On perusal of the FIR, it appears that the allegation made with regard to commission of offence under section 3 of the SCST Act is against the mother of the present petitioner. So far, the present petitioner is concerned, which is the husband in this present case. No case under section 3 of the SCST Act is prima facie made out. And subsequently, the mother has not been charge sheeted. And the FIR has been registered after a span of 11 years.
What are the allegation?
Allegation is that, my lord, there was a love relationship in the year 2009 with the present petitioner. In the year 2012, the victim approached the petitioner for marriage. Due to the caste, the petitioner belongs to Brahmin caste and the victim belongs to the SC caste. The family of the petitioner did not agree to the marriage. As a result of which, they parted their ways. In the year 2016, the petitioner got socially married. He has 2 kids. There is a birth certificate and he has been serving in the CRPF. In the year 2023, she comes up and says that he is my husband. How can he marry?
IA for what? What kind of complaint this?
Trial court, it is stayed, my lord.
Trial court proceeding is stayed.
Yes, my lord.
The problem is the marriage is not valid.
No, my lord.
You were in relationship. And how section 3 will has he scolded you saying that you are lower caste?
No, my lord.
The only thing is not agree to marry.
Yes, my lord.
No case is made out.
And FIR is after 11 years, my lord. No purpose.
Let this stay continue. The learned counsel for the opposite party number 2 is seeking 1 week time to file a reply to the main petition. Release the matter on show. The interim order of stay. When was the stay order passed?
My lord.
The interim order dated 4/9/2024 shall continue. Yes.
Grateful.
My lord, it's may I please your lordship? I am
yes.
The petitioner challenged the order of cognizance in this case. The background of the case is that on the first information report 307 and other offences were registered against unknown persons. Thereafter, in the year 2017, a person was arrested and he alleged that he committed the crime at the instigation of the present petitioner. The person who was arrested, he faced the trial and ultimately no material come out against him that he participated in the alleged incident and he was acquitted. I have filed a copy of the judgment before your lordship and also the evidence of the injured witness. There is no allegations against me either way, either as a conspirator or participant in the alleged crime. That's why I challenge the cognizance order and the criminal proceeding that it is a fruitless effort if the trial will continue in view of the development.
Show me the evidence of injured witness.
Injured witness is the annex
Page 66.
page 66, madam. Annex 4 series, madam.
Yes. Have you gone through?
There are certain nitty-gritties involved in this. Very short adjournment is provided and provided.
What he says is the basis of confessional statement he has been implicated, and the main accused faced the trial, he has been acquitted.
Yes.
And the injured witness has not supported the case. Why should he face the trial? He is seeking an adjournment.
This is the fourth time, my lord. They are seeking adjournment. This is the fourth.
Okay, by way of last and final opportunity, one adjournment is granted to the counsel for the state. Please. Let us see. I'll hear you if it is necessary. I'll issue notice. Okay. Yes. Release the matter and so on. So interim order.
No, interim order which nahi.
Okay.
60. Your lordship, ma'am.
What is the stage?
Case is 307 of the
No, state. Cognizance is taken. Nothing is. Have you appeared? You got the bail?
Yes, I appeared. The case was not committed.
It's not even committed. Okay.
Your lordship may fix a date. It will be more.
No, prosecution evidence qua the other accused, not him. Okay. Fix a date. After 2 weeks, yes.
60.
Oh,
The
order of convenience 2023. Taken against the present petitioners who happens to be the husband and in-laws of the wife. In the meantime, divorce were already granted. Divorce was granted by the alimony of rupees 2 lakhs, and that alimony has been enhanced by this honorable court in matrimonial appeal.
What about the service?
Service instead of notice that last 2 days to occasion.
Somebody appeared, filed Vakalatnama.
Last occasion also it was adjourned for that. Since nobody has appeared.
Effect service through the IIC, entry mode to continue. IIC of this so entry mode to continue.
61.
May I please, your lordship? Lordship, this application for disseal of residential house. Last occasion, your lordship has seen the IO report, and I have filed an additional affidavit against the IO report.
Yes. What are you seeking here?
Disseal of residential house. Unseal.
Unseal the residential house.
Yes, my lord.
The last.
What are you? What is he saying? What is he saying?
IO was saying that the accused person did not cooperate with the investigation, and I have filed an additional affidavit. IO has falsely reported that we are not cooperating with the investigation on November 27, 28, 29, 13th, and December 4. IO wanted our presence, and also the accused person and the present petition are appeared before the IO. IO has falsely reported this report before this honorable court. If the accused person did not cooperate with the investigation, there is a provision under the bail term and condition. If the accused person did not cooperate with the investigation, their bail will be cancelled, and the such IO did not inform the same before the trial court and reported before this court.
Do you have a grievance against the IO?
Yes.
What grievance?
I was falsely. I have always cooperated the IO with investigation.
The IO says you are not cooperated. You go and appear.
Your lordship, I have filed affidavit that I have presented.
He says that when are you going to appear? You tell me.
Yes.
When are you going to appear? I'll record that and dispose of. You won't appear.
Always I am appearing. And
once more he appear. That's what he says, that he is not cooperating. That's why the matter is not proceeding. That's the report.
the problem is that my residential house sale and I am the senior citizen person. In the property is two per builder house and every house is sold and I am staying with
All these things are
square.
but you will not cooperate with the investigation.
No. The IO report falsely be marked up against me.
Why IO is against you?
I can't say.
You can't say, na? Then why IO, unless you say that IO is demanded money or IO done this thing, that thing.
No.
Then I can understand.
Yeah,
Nothing. Why should he be inimical to you?
I can say, but I am always cooperating with the IO.
But he gives this written instruction that you are not cooperating. Go and appear.
My lord, my lord, can I submit? I will just bring the FIR. FIR the early.
Go and appear before IO. He says that you are not appearing. Then counsel, Mr. Tej Pratap has submitted a written instruction from IIC Tirtol PS in regard to the FIR number, Tirtol PS case number 337 of 2024, corresponding to GR case number 401 of 2024. The written instruction indicates that the present petitioner has not cooperated with the investigating officer. Therefore, the matter is not proceeding further. The counsel for the petitioner, on the contrary, submits that the petitioner has been appearing constantly before the IO, and he has also filed an affidavit. Where is that affidavit?
Affidavit.
Where is that affidavit?
I have filed on additional to January 3rd. I have filed.
Where have you said that you have appeared?
4. Para 4, Para 2.
Which affidavit that is? Where is that affidavit? The affidavit is not there. Affidavit is not here.
My lord, I have already.
Where is that affidavit? Submitted that. Para 4.
Yes. Para 4, Para 2.
Filed affidavit inter stating that on 27/11/2024, 28/11/2024, 29/11/2024, 30th/11/2024, and on 4/12/2024, the petitioner has appeared before IO. I am not inclined to enter into the controversy as to whether the petitioner has appeared or before IO or not. But suffice is to say that the petitioner is required to appear before the IO on date without on Friday. Friday date. Friday, what is that date? 10th at 2 p.m. And the IO is directed to do needful in this matter and submit a report on the by next date of the year. Okay, lease the matter after 2 hours. Friday, 2 o'clock, he will go.
Yes.
Don't make any issue out of it. Whatever you want to do, do it. 2 o'clock, you go and appear and finish it up.
And my lord, I sought that for.
I will give you. After 1 week.
Oh, blessed.
Yes.
62.
May I please your lordship, my lord. I am VCR Puri. I appear for OP number 2 through VC, my lord, and pray to take some time for filing counter affidavit, my lord.
You are counsel for the opposite party.
Number 2.
Panigirai, T. Panigirai, appears for opposite party and seeks time for filing counter affidavit. Lease the matter. Yes.
3.
My lords, I'm entering appearance for opposite party number 2 today. We filed the work.
You are filing counter?
No, my lord, work. No, I'm entering appearance for opposite party number 2 today.
So also entered appearance for opposite party number 2. File the filing the counter. And 6.
I filed the counter.
1 week time to file response to the petition. Lease the matter on Saturday. Entry mode to continue.
64.
In fact, to start with, my lords, there has been a truce between my friends and me, my lords. We are touching sword with each other, but now I confide to my promise to him, but he expects me to confide my submission of the 2 pages note which are prepared, my lordship. In this is that case, my learned friend's entire thrust of submission confined that as for the note they have filed at flag B of lordship brief notes. Okay, at flag B, my lord, they have filed in a petition on in fact notice submission at page 6, lordship turn to my lord. That is the thrust of the submission, that as per their own calculation, the DA amount has come down. Set it forth. That pink flag notes.
Come down to
Pink flag notes. This is the pink flag, and in that pink flag, my lordship turn to page 6, the exact portion, my lords. In that particular note, so page 6, my lord.
yes.
Page 6 indicates, and the your lordship can turn the last paragraph, that is a percentage is 6.77%. As per their calculation, the DA amount ought to have been 6.77%, my lords. And but the charge sheet at page 49 of the lordship brief, my lords, at page 49 of the revision petition, my lords, he has given the charge sheet at page 49, my lords.
Have you got the?
I got. I will confine this I prepared it on 2 pages only. This will be.
I'll put it for hearing. But I don't want to reserve the judgment further.
Correct.
Because I have accumulated a lot of work. Let me finish it.
If a lordship permits, without placing it, my lords, I confine my submission in 1 line, my lords.
I know this matter because I have heard it.
Because
he says that if for the plain calculation you make
7%.
falls down to 7%.
And as per the charge sheet, it is 39%. And this play doesn't pertain to the charge sheet of the material produced by the prosecution.
So according to you, it is 39.
It's 39%. So the charge sheet, 38. Okay. So materials on the charge sheet and the material produced by them as per their own calculation are bristling with contradiction and inconsistencies. That's why, my lord,
needs to be thrashed out in the trial. That's
all. And secondly, my lord, and the end party judge.
I'm not hearing now. I will hear it. You date fix for the hearing period.
Reserve, sir,
No, I will not do. I will not reserve further because there are a lot of judgment reserve. I have to finish those things. Otherwise, this burden is on.
It's a short date.
The entire exercise will not that the other bench balance are already stayed. Not say business case has been stalled.
After a week or so. Yes. Next.
At 2 p.m.
Next.
65.
Yes.
Lordship, record I filed a note of submission.
Mr. Das has sent video.
In response to note at black.
Note of submission. Submission. Release the matter for further review. Yes. Yes.
There are 3 appeals.
For hearing.
Yes.
I'll hear it. Because see, the problem is I can't write the judgment now.
Let's explain in that case, previous case also.
Because there are,
we appreciate
lot of appeals are there. Let me finish it. Thereafter, it is a better thing, you know.
He is filing the written note of argument today and supplied the copy just now.
You also get ready. So I'll take, what I'll do is, I'll hear it and here and now I'll give dictation and finish
it. I will take only 5 to 10 minutes.
But Mr. Das doesn't take that much time.
I think my learned senior also will not take much more time.
No, just now I received the written note of argument and the decisions which I had relied on before the Honorable Judge of a similar case.
My learned senior of the council, he argued the matter.
He has relied on the same decision. I will have to find those decisions in order to support my department, State Vigilance. So I will have to prepare one written note of argument and to be filed before your lordship.
Okay, so
written
note.
In order to
Mr. Pradhan files a written note of. Would be filing a written note of submission in the registry by tomorrow. Advance copy of the same is supplied. Already advance copy has already been supplied to Mr. Das. Mr. Das seeks a short adjournment to file his written note of submission.
Along with citation.
Along with the citation, this is the matter for hearing. After 1 week, 1-2 week, he give it. I'm trying to finish up all the work so that I can hear it. And
Your lordship should hear all these matters.
I'll hear it.
Because judicial is expected from your lordship only.
But I see the kind of assistance you are getting accordingly. I'm trying to do it.
Yes,
In many cases, what had happened is I reject the judgment. I've said that written note to be filed. Written notes are not coming forward. I'm reading myself.
So we are getting pleasure by arguing before your lordship.
So I'll put it after 1 week so that I can hear.
Yes,
I have some difficulties in my.
You tell me when do you want.
Any day, your lordship.
You tell any of your choice.
On 20th, any date, 20th.
20th?
1 week I will take for preparation of, because all the matters are there.
Because see, there are many matters. We can finish it up, all the matters. 1, 2, 3 appeals we can finish up one go.
Yes, yes.
That's good.
3 appeals.
Any day, your lordship. 3 convenient, your lordship put that date.
Your lordship may fix it any convenient date.
22nd, 23rd.
Starting from 20th.
22nd?
22nd, yes.
Let it be 20. No, if you put it on 22nd, 23rd is a holiday, I can utilize that. That's the reason.
I will not take more.
Let it be 22nd. So that 23rd is a holiday, I can utilize that.
Yes, yes.
That is the reason.
Yes, yes.
Okay. 23rd.
I'll prepare short note of.
Yes, please do that.
Law remains the same, even if you change the sign. Even if he has changed the sign.
His small written note speaks volume. That's the problem. Yes. Yes, Mr. Passport. One passport, madam. 53. Yes.
Here, in this case, I'm seeking quashing of the 1cc case.
May I pray another matter which has been fixed to 3:30? It may be also posted to 22nd or 23rd. Mr. Padi's case. That purchase of land.
Yes. I can't hear.
Fixed to 23rd, 24th?
Oh, 24th.
Mr. Padi, Prasanna Kumar.
Yes,
Padi.
My lord, Mr. Padi is on his way. Just on his.
His lordship is saying that.
He is entering.
Yes. Cannot dictate judgment, so that his lordship is saying that to fix it.
Mr. Padi, I'll just adjourn your matter for a short this thing.
Short.
Tomorrow?
No.
Not tomorrow. Tomorrow may not be.
Today.
No, I'll just adjourn it to a shorter date, whatever possible date.
As my lord
I'll just accommodate it.
No,
I'll just see. I'll try and.
Hopefully. He has devoted from the post of secretary to lower post assistant. Now they are giving sugar for dismissal.
Before that, I
What I am saying, my lord. Can it be on Monday or Tuesday?
I'll just check it up. If possible, I'll do it. Let me check it up. Okay. Yes. Yes.
We are not going to dismiss you.
He's assuring you what you
No, we are not dismissed.
If that mode of command will be done, then I am nothing to say.
And both the powers are with them. Both state and center. Both state and center.
You can prevent it.
State and center. Both are under their control.
Yes.
But here, I have prayed for quashing of the entire 1cc case. The pending before the SB Parish. My lord, may kindly turn to page 10.
10?
10 of the bill.
Yes.
My lord, your lordship will see name and address of the complainant. Pradeep Kumar Das, son of such and such, authorized representative of Messrs. Megha Quills, such and such. Now your lordship may kindly see the averment at page 11.
Yes.
The complainant Pradeep Kumar Das, son of late Purnachandra Das, is the authorized representative of Mega Fuel such and such. The wife of the complainant, Srimati Sujata Shaw, alias Das, wife of Pradeep Kumar Das, is the proprietor of Mega Fuels on an outlet of IOCL located such and such, where upon the complainant is the authorized representative to take care and look after the said business. So, my lord, who is the owner? Owner is the wife of the complainant. And she is the proprietorship form, proprietress of one Mega Fuels. But the case has been filed by
The
husband claiming that I am the authorized representative. Now, your lordship may kindly turn to the documents. My lord, we kindly see at page 30.
Who has issued the check?
Check has been issued by my client.
Yes.
Page 30, your lordship may kindly see. That issuance of check is not in this.
Yes. 130.
My lord, page 30.
Yes.
Paragraph in the affidavit that the wife of the complainant, Sujata Shaw alias Das, is the proprietor of Messrs. Mega Fuels. The complainant is the authorized representative to look after the look set after the business. So this was the affidavit filed in conformity with paragraph 1 and 2 of the 1cc petition. Then, my lord, may kindly see the check at page 18.
Yes.
Check has been issued in name of Mega Fuels. There is 18 your lordship has got it.
Yes, I got it.
Mega Fuels given by said answer. The check bounced. My lord, my case before your lordship is now, before I argue my case, your lordship may kindly see one interim application number 2649 of 24 has been filed by my learned friend before your lordship.
2649.
Yes. There they had annexed a document at page 24.
Yes.
They rely upon an authorization letter issued by Mega Fuels to your lordship may kindly see. My lord has got it.
Yes.
The undersigned Srimati Sujata Shaw, such and such, nominate and authorize and appoint Sri Pradeep Kumar Das and such and such, who is my spouse, stroke husband, to act as the lawful authorized person of my firm, Mega Fuels. Here, the contents your lordship may see that I am physically not sound and have been advised by the doctor to take bed rest, so I appoint Pradeep Kumar Das as my lawful authorized representative to look after all business matter of retail outlet Mega Fuels on behalf as follows. To appear before all government officials, it is just like a power button. But their trump card is that this authorization letter is there, which empowers them to file the complaint petition. My argument will be in this way. But suppose a person it's a proprietorship firm, no doubt, it's a proprietorship firm, and a power of attorney holder can present the application. But power of attorney holder cannot depose in favor of
That's the law.
That is the law. Here, the
Personal knowledge.
Personal knowledge. Here, your lordship may kindly see the cognizance has been taken at page 60. No, the deposition.
Yes.
I have filed my examination in chief in the shape of affidavit, which has been drafted as per my say. It has been read over and explained to me in Odia. After understanding its contents, I have put my signature. I have filed the original document, check such and such, he puts, this is the cross-examination. But my humble submission before your lordship is that the husband cannot file the case. The wife could file the case, represented through power of attorney holder as the husband. If that would have been the position, then I could not have possibly approached your lordship. But here an argument can be advanced that in a case of I place those judgments, my learned friend will be obviously placing that I will answer subsequently. But there are judgments of this honorable court where a company how a company is to be represented. For company, my lord, it is a different. The board of directors may authorize one person to file the case on behalf of the company. But here the complaint petition, your lordship will kindly see, has been filed by whom? Pradeep Kumar Das, authorized representative of Mega Fuels. My lord, at best what would have been done? Mega Fuels, represented by proprietor such and such, power of attorney holder of such and such, Pradeep Kumar
Yes,
Das.
yes, madam.
Yes, Your Lordship.
My lord, I.
Your Lordship, my first leg of argument is, Your Lordship, nowhere in section 142 that says how to raise a complaint, Your Lordship. That says that only a power of attorney holder can file a complaint. The particular words are person who has been authorized, Your Lordship. And Your Lordship, there are, first of all, the word complainant has not been defined under section 142. So it is not always necessary that there has to be a power of attorney holder. Rather, the term that is to be taken into consideration is a person who is duly authorized. Now, how it is to be seen, how a person is to be duly authorized?
Yes.
It is to be seen, first of all, from the complaint. My learned senior has challenged the cognizance order and rest of the proceedings. So, Your Lordship, first, it has to be looked upon into the complaint, Your Lordship. The complaint has been very well annexed in the petition, Your Lordship. In the second paragraph of the complaint, it has been very well mentioned that I am the authorized representative of the company, Your Lordship. There is no single judgment or no precedent in law, Your Lordship, neither the statute that says that only a power of attorney holder can file a complaint for a company, Your Lordship.
It's not in a company. It is
Your Lordship, even if it is a proprietorship firm, I am covered under section 140.
The question is, how can you depose before the
Your
court?
Lordship, because I am represented.
Personal knowledge of your wife.
Your Lordship, that is to be seen from the complaint. Whether I had personal knowledge or not, that is to be seen from the complaint.
No, come to your legal notice.
Your Lordship, may look
Come
at
to your legal notice.
legal notice. Yes, Your Lordship.
Come to the basics of it.
Basic, yes, Your Lordship.
You had given instruction
Yes,
to the
yes.
lawyer to issue the notice.
Your Lordship, legal notice.
On behalf of
and
Pradeep Kumar so authorized.
Next, page 22, your lordship, kindly see.
No, that is there. I have
Yes,
just
Your Lordship.
being instructed by my client named above, who is Pradeep Kumar Das is
Yes, Your Lordship.
instructing.
Mega Fuels, petroleum products, whereupon my client Pradeep Kumar Das is the authorized representative to take care for managing and look after the management of business. From the very inception of the case, I have made it clear that I am the one who is having personal knowledge about the transactions of the proprietorship, Your Lordship. From the very inception, I will show Your Lordship's judgment where it has been held that it is to be seen from the facts of each and every case that whether the person who is filing the complaint had personal knowledge about such transaction, Your Lordship. So, Your Lordship, in the complaint itself, I have stated, in the notice itself, Your Lordship. Thereafter, in the complaint also, I have stated that I am the authorized, not only I am the authorized representative, but I have knowledge. Whereupon the complainant is the authorized representative to take care and look after the said business, Your Lordship. Then again, Your Lordship, during the filing of this petition challenging the cognizance order, I had already deposed before the Honorable Court below, Your Lordship. I had already deposed below, and that evidence is at page number 17, Your Lordship. I have filed an initial affidavit, and in page number 17, it is said, I have filed the original authorization letter dated 19/8/2016, issued by Sujata Sahu, proprietor of this.
Yes.
Your Lordship, and to support this, Your Lordship, Because during the filing of this petition also, the learned court below had already taken into, I had already exhibited my authorization letter, Your Lordship. Now, what is the position of law as to held by the Honorable Apex Court, Your Lordship? The first judgment that I have also provided, Your Lordship, is that of TRL Krosaki Refractories. That also arises from a judgment of this Honorable Court, where this Honorable Court had quashed a proceeding, Your Lordship, on this ground, but the opposite parties had approached the Supreme Court. Your Lordship, in Paris 17 of that particular judgment, that is at page number 23, Your Lordship.
23.
Yes, Your Lordship, page 23.
Yes. Yes.
I take Your Lordships to Paris 17. In that view, the position that would emerge is that when a company is the payee of the check based on which a complaint is filed under Section 138 Act, NI Act, the complainant necessarily should be the company which would be represented by an employee who is authorized.
That's the company.
Yes, Your Lordship. Your Lordship, even if taking into account, this is not a company, Your Lordship.
That's not the issue. Just see.
The person.
Come to 138.2.
Yes, Your Lordship.
Come to 132. 2B.
Your Lordship.
Come
yes.
to 130.
Yes, Your Lordship.
Read. Who can give this?
The payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount. Here it is Mega Fuels, Your Lordship. Here it is Mega Fuels. Yes, Your Lordship.
So then Mega Fuels has to give.
Mega Fuels has an authorized representative.
That doesn't extend to the authorized. See, the notice, that is why I am emphasizing. With the foundation for 138 case is the notice.
Yes, Your Lordship.
That's the statutory notice. If the notice is bad, everything falls in line. Everything is bad. So the notice, the authorized under the act is the payee or the holder in the due course.
Yes.
Holder of the account of the due course. The language of the notice, just see. Pradeep Kumar Das, so-and-so.
Yes.
On being instructed by my client as named above.
Yes.
Means that is Pradeep Kumar has instructed.
Yes, Your Lordship.
Whether he could have, I can understand.
Your Lordship, because
for the purpose of giving notice, Mega Fuel could have instructed.
Your Lordship, that is what is my contention, Your Lordship. Mega Fuel's authorized representative is Pradeep Kumar Das, Your Lordship. That is what both the judgments that I've given, Your Lordship, that also talks about the language of both 138 and 142, Your Lordship. When you are talking about proprietorship, firm, company, just the opposite case, Your Lordship. I take Your Lordships to just the opposite matter.
The company, you are correct.
Yes, Your Lordship. Even a proprietorship firm, Your
Holder pay is a company, means somebody has to, because it is a juristic person. If there is a juristic person, somebody has to represent.
Yes, Your Lordship.
So anybody
Same
can do.
case here also.
And no. Proprietor is not a juristic person.
Your Lordship.
If it is not a juristic person, then in that case, personal knowledge comes. If personal knowledge comes, 138 to B says pay, means it is the person. It is the person. Get some judgment.
Your Lordship, I have had there been time.
Do some research.
Yes,
you are very good at that.
Yes, because I also wanted to take Your Lordship through this particular point. Your Lordship may fix it to another. I'll take through these judgments only. I'll
Very tricky things. Because it is you are prosecuting. You are prosecuting.
Yes.
Then in that case, the personal knowledge, how will you?
To proprietary firm can be considered.
You got for some judgment, Mr. Bose. You also get the judgment. Personal knowledge.
Yes.
Got it? Pass on to her.
That is my crank fact that I'll show the last stage.
That judgment also.
She might have gone.
She is more thorough than me.
She is doing very well.
She is more thorough than me.
But my
so this is a very good, interesting question. Let us answer it.
Yes.
This case, one case may lose, may win. That's not the issue. This issue has to be addressed.
Yes.
Who is authorized under 138 proviso 2B to issue notice?
Yes, Your Lordship.
One thing I'll tell you. Like in Orissa, we have an Orissa amendment wherein SR 575, there is an amendment that a lady is exempted from paying of court fee. But an interesting case came up before this one, where a lady was a proprietorship of a firm. It's a proprietorship.
Yes. The firm has to pay or not? Yes. That was the question.
There, this honorable court had no. Because that firm is not being separated from the lady.
It's not a juristic person, so.
Not a juristic person.
Yeah.
So she is an individual capacity, she gets the benefit of that. Here, my lord, if the lady would have filed the case through his power of attorney, my lord, matter would have been different. If the mega fuels on the instruction of my client, of my.
What indirectly what you are saying is Mega Fuel is not prosecuting you. Pradeep Kumar is prosecuting
Yes,
you.
Your Lordship.
That's what you are.
That is what his.
Long and short of the matter. If Mega prosecutes you, you have no problem.
Yes.
Represented by XYZ. But XYZ can't prosecute you because you have no privity with him. That's the long and short of the submission. Yes.
Pardon, my lord. One mention, my lord. I have to. My lord, yesterday there was a matter, BDA eviction matter. My learned senior was doing the matter. My lord has directed to post the matter to tomorrow, my lord, on 8th. My lord, it was in the order sheet, it was typed as 10th, my lord. The matter is on tomorrow, my lord, in the lower court, matter is there, my lord, in the tomorrow.
Already they uploaded, then I can't.
My lord, that is uploaded, my lord.
Then you remove application for. I can't do it like this.
My lord, then.
Yes.
Oh, sorry.
The argument was heard already. You keep it with you when I take it up and just pass on and I'll. Okay.
Your Lordship.
Thank you.